Are you Monique Wynn?
Yes, ma'am.
And Ms. Wynn, this is your initial appearance in cause number 24-1298. You're charged with the state jail felony offense of theft of property from April 8th of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, I had a lawyer.
Right, so when you're in custody, we automatically give you a court-appointed lawyer. But now that you've bonded out, what I'm going to do is give you some time and ask that you try to hire your own lawyer. So I'm going to reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before that next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the people you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? All right, if you'll step in front of the clerk right here, she'll give you your reset notice. Jamarcus Zarate Jones. Good morning. Are you Jamarcus Zarate Jones? Did you get someone hired?
Well, I talked to 3 lawyers.
Okay.
Lori,
Keep in touch with the bonds.
Lori Parenzo,
Mm-hmm.
Lori Crenshaw, and Kate John.
Okay. And so where are you on being able to get someone hired? Pull your pants up. Just wearing a belt doesn't do it. Pull them all the way up so that I can't see your underwear sticking out the front. And nobody wants to see it sticking out the back. You understand? Okay. So where are you on being able to get someone hired?
I'm not physically fit.
Are you working?
No,
Why aren't you working?
because these charges currently.
Okay. Were you working before?
Yes,
How old are you?
I'm 21.
Okay. So you're on, have you been going to probation like you're supposed to?
Yes, ma'am.
So where do you live? Who pays your bills?
Family, deal with family.
Okay. Hi, good morning.
Good morning. I just wanted to make you aware, the charges haven't been filed yet. We sent over a hearing last week to second amendment because he was arrested again here in Jefferson County. So he has 2 more charges that should be filed.
What'd you get arrested for?
Just being with the wrong crowd at the wrong time.
Sounds like you are the wrong crowd. You're not? You're on probation for theft of a firearm and you've been arrested twice now? Since this, right? Is that what you're saying?
Yes, ma'am. Well, he was arrested in March, but he was also arrested June the 18th for possession of marijuana and unlawfully carrying a weapon.
Have a seat in the jury box. We're gonna have you tested and then I'm gonna decide what to do. I guess that's still, I'd like to see that administrative hearing, but I guess it's still maybe in the process. I don't, it's not scanned into the file. I don't know if it would be still. What's her name? Ms. Martinez. Do you know if I already signed off on that last week?
And when I checked Odyssey this morning, it hadn't been scanned. I'll go look in the box.
Okay, yeah, check, yeah, and if not in my box, check, Kelly probably would have already got it done, so it might still be in my box if you'll look, please, thanks.
And there was nothing in the mail, so Friday.
Okay. Mark Garcia. Good morning, sir. Are you Mark Garcia?
Yes, ma'am.
And Mr. Garcia, this is your initial appearance and cause number 250120. You're charged with the state jail felony offense of theft of material. And that's from April 7th of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a
I
lawyer?
have not, but I can get on that.
Okay. I'm looking at your indictment. You have several prior offenses, so it's very important that you go ahead and try to get somebody hired before that next court date. I'm going to reset your case for about 30 days to give you some time to do that. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're not able to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the people that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand? All right, if you'll step in front of the clerk, she'll give you a reset notice. Yes, sir. Kaylin Salzar. Good morning, ma'am. You're Kaylin Salzar?
Yes, ma'am.
And Ms. Salzar, it looks like this is, wait, did you hire someone?
I'm just waiting on her to give you.
You hired Rife?
Yes, ma'am.
Okay, I see the letter in here. All right. And he said he was going to come this
Yes,
morning?
ma'am. He said he was gonna push for the release.
He is? Okay, I'll hold it till he gets here.
Yes,
Thank you,
ma'am.
ma'am. So I gave him a bond on this MTRP. Hold on a second, let me. Mr. Coleman,
Yes, yeah,
this, Mr. Zarate Jones
yes.
is yours. And I know you don't have it because he's on an initial, but there was a motion filed to reset a bond for his probation sometime back in April.
Did I not file a reply?
You did, which I obviously,
Be safe on your trail.
Good morning, sir. Let me get up to speed here. Timothy Raymond McLaughlin.
Your Honor,
Yes,
he will need a court-appointed attorney as well.
yes, and a ride home. Mr. McLaughlin, you got a ticket on June 8th at 5:43 p.m. Michigan Street and 5th Street for driving suspended. That's all I know. Let's take a look at your driving record. You're revoked. which I won't go into, which means you got a lot of baggage on your driving record. And you didn't show up for your hearing on June 24th, and we rescheduled it for today.
Yeah, that was all me.
All right.
I looked at the date wrong. It was-
All right, well, you're here now. But you drove here.
I did. My girlfriend is in the passenger seat though. She's gonna drive home. She just wasn't feeling well this morning.
All right.
I mean, it was that or don't come, so.
Your license is revoked. You can't drive. You don't
I
show up
gotta
for
live
court.
though.
No, I can't fix it. Well, you can keep driving if you want to go to jail. In fact, you can drive back to Three Rivers if you want, and we'll have your car towed and impounded before you get back to the city. You can't drive. Your license is revoked for a bunch of bad conduct. And I can't fix it. So now you got a new drunk driving charge, which is
What?
a new driving suspended charge, excuse me, which is gonna make it more difficult. And people tell me all the time, hey, I gotta get back and forth to work, and I sympathize with them. Oh, your package is,
2 OWIs and a speeding ticket.
yeah, driving suspended, but those old, they got a long memory. They're 10 years old, or older, and it's a hard burden to overcome. And I tell everybody, when they get a second offense, they get revoked. Unless you're in a sobriety court. Live, plead not guilty. Your girlfriend's in the car now?
Yeah.
Does she have a valid license?
She should, yeah.
All right, let's make sure he doesn't drive. Well, if he drives, we'll just have him pulled over on the way to Three Rivers and impound his car and take him to
Maybe on
jail.
private property, so.
Find attorneys, set attorney pre-trial for August 1, 2025 at 8:30. Defendant drove illegally to court. Where do you work?
River Trail Apartments. In Three Rivers, I do maintenance.
All right, so you live there, so good news is you don't need to drive to get back and forth to work.
No, I was really just taking my uncle a
All right.
birthday present.
All right, let's stop driving until we get this sorted out, but it's just gonna get worse and more expensive and doesn't have a happy ending. All right, you're good to go. Make sure your girlfriend drives home. What's this? 251109. The Tommy Willis. That's you, sir?
Yes, Your Honor.
You win the prize for best dressed today.
It's an honor, sir.
Shows you have respect for the process. All right, Mr. Willis, let's take a look at your ticket. I'm gonna have the same advice for you as I did for everybody else. Appoint an attorney to assist you with this. This is alleged to have occurred on May 16th in Nottawa Township, operating while intoxicated. Punishable by up to 93 days in jail and a fine of up to $500. Another one that's over .192. We've become jaded. The legal limit to drive a vehicle is .08, and we routinely see these really high ones. And you're about the third person today that was stuck in a field someplace. Anyway, I'm glad you didn't hurt yourself or somebody else. And I don't know why the prosecutor, they have the discretion to charge it as they see fit. So I guess I'll just go with them. Anyway, you didn't get charged with high blood alcohol level. What do you do, sir?
I'm a press operator at TH Plastics.
What shift are you on?
First shift, sir.
So you're missing work too?
They took me off of the schedule for 4th of July week. So
Oh, just not as a punishment, but just as, oh, so you got the week off.
Yes, Your Honor.
All right, well, this is not a very good day to spend your day off, but we'll get you back on your way. A show plea of not guilty,
Yes, Your Honor.
set attorney pretrial for 8/1/25 at 8:30. I'm gonna be busy on that day. Don't know anything about it. Your driving record looks pretty good. No, I don't have a driving record. I don't know what's going on today. Well, you don't owe me any money. Anyway, you're here on time. You show respect for the process. You got printed. That's another one. I don't know why people aren't getting fingerprinted when they get arrested for drunk driving, but I guess I'll do enough ranting for today.
The power was out when they brought me in as well, Your Honor.
Was that May 16th?
Big storm.
Yeah, well, we are all sitting around in the dark that day. Yeah, May 16th. Okay, good luck, sir. I'll see you on August 1st.
Thank you.
Thank you. Christopher Simonson, Independence, Iowa. He isn't here. We had 8 drunk driving cases today. One hired a lawyer and got moved and one didn't show up. This guy. What's the last guy? I think that's all of our arraignments.
Did you call Blake Brown maybe when I was out of,
No, I didn't. Let me see what the deal is. Blake Brown was crossed off. I wonder if he's related to Blind Blake from the killing floor. He retained an attorney and he won't be here. It's been reset. And that is Jordan's sentence. He apparently complied with the terms of his, as much as I'd like to see her, she can be excused and so can a client. Good morning, Mr. Lavador. This is Judge Middleton. Judge Pattison isn't here this morning, so I gotta handle this. Jeanette Jackson from the Public Defender's Office is here with me. This is file number 242298FY. The charge is uttering and publishing false bills and retail fraud in the 3rd degree. Paul Gibson is your lawyer. This was originally a felony and it got reduced to a misdemeanor. You failed to show up for your sentence. They did a show cause on your bonding company. Nobody showed up for that. And then you got picked up. Did you get picked up last night?
Yesterday,
Where were you staying?
on Haynes Road.
Oh, I thought that house got condemned or something.
No, there's, I'm moving here shortly, so I don't know what they're gonna do with it.
All right, well, it's not your house, so I guess that'll be their problem. How'd you get picked up?
I ride my bike.
You've also got a no ops ticket pending with Judge Pattison for July 10th. So I'm gonna set this for sentence with that case.
Mhm. Was that for the moped?
I guess so. That, you haven't been convicted of that. That's at 2 o'clock.
Okay,
And that case is maybe 10. Give me a second. That case is file number 2. Oh, it's an old case. 24-8. That's an ordinance. You've got multiple unpaid fines and costs in files 234 ON, 23258 SM, 211751. They've been trying to get you in here for weeks, months. This is a 2024 case. You're like a will-o'-the-wisp. You also cheated some old lady out of $1,250 on a construction job over in Maple Street. She sued you for $1,250 in small claims court. You didn't show up. And so there's also a small claims judgment against you. I'm gonna leave all this for Judge Pattison to try to deal with. The no ops in this case, set for July 10th. This is gonna be the year you spent the 4th of July in jail because I'm canceling your bond. They forfeited your surety bond. And you need some time to just get squared away. So the matter is set for July 10th with your other case at 2 o'clock. Your lawyer, Mr. Gibson, is scheduled to be there that day, and we'll let Judge Pattison have time to take a look at it when he gets back from his vacation. Mr. Leverett, hope you get a couple of good sleep days here. He'll see you on the 10th. I said I won't go into the reasons, but I generally don't do his cases, but. All right, let's take a recess. We got 13 minutes before we start our next batch of civil cases. Then we'll segue into some sentences and then hopefully we'll get lunch. All right.
Okay. Are you working?
There's a hearing set.
Okay, so I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Thank you for doing what I asked and contacting those lawyers. You're gonna step in front of the clerk. She's gonna give you that paperwork. Make sure you fill it out accurately and completely. You're gonna swear under oath that everything's true and correct in it, and then I'll take a look at it. Okay?
For some temporary.
Ronnie Oliphant. Good morning, sir. You're Ronnie Oliphant. And Mr. Oliphant, did you get someone hired?
No, ma'am. Almost there. I was trying to see if I can get the next extension.
Who are you trying to hire?
We're just
Someone
asking.
down in Houston that I was referred to. They had 1,000. I almost had the next.
What's the name of that attorney?
I'm not sure. I had the paperwork.
Where?
It was in my residence. I think in my car, man. I just gave him a call one time and I was just gonna hire him.
Okay, so you didn't think it, when you were here before and I said, go talk to some attorneys or get someone hired, bring me the names of the people.
Right.
So I need that name. I need to know what you're gonna do. Because if you didn't talk to 3 and you're planning on hiring this one, I wanna know who it is so that next time you come in, I know that you're doing what you're saying. So I need you to figure out who it is.
Oh, yes, ma'am.
I'm gonna hold your case for just a few minutes, figure it out. Don't leave, because I'm gonna recall you back up here.
Okay.
So go figure out who it is that you talked to and who you're gonna hire.
Okay.
Lisa Pratt. Lisa Pratt.
Back in October of 2024 because of the fact that it incorrectly lists your income at $5,000 plus and that you have been incarcerated since April of 2024 on pending drug charges. Is that correct?
Yes, Your Honor. There was a few other points that I wanted to try to address while we were here today, but that was one of the main ones that I had sent in. I had sent in a few motions to the court that the clerk's office had received. One of the other things that I wanted to address, if I can speak freely.
Well, if you're going to testify about what you want changed, then I need you to raise your right hand. Let me place you on the road. Do you solemnly swear or affirm the testimony about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. What else are you asking for?
I was gonna try to address the no contact order that the plaintiff has said has been in effect since we last went to court. I wrote a cease and desist letter that I actually sent to Mr. Hawley and to the clerk's office, asking them to, let me know about the no contact order that the Christie said that she had. I wrote the clerk's office asking them to send me anything on file that they had saying that there was no contact order. Our parenting plan doesn't have a no contact provision in it or anything. I haven't been allowed to talk to my daughter for the duration of my stay while I've been incarcerated. And the second point that I wanted to see about is letting my dad, who's here in the courtroom, and my stepmom utilize my parenting time so that I can adequately visit and communicate with my daughter. Because I don't believe that at this time that the mother will be willing to accommodate those. That's all, Your Honor.
All right, Mr. Hawley,
Judge, we did not know it was
you
set
need
for
to
today.
speak before the microphone for him to hear you.
I think, well, we didn't know that it was necessarily set for today. I don't know if it was set today to get a date to hear his motions or whatnot. Mrs. Thornberry's not here. I haven't reviewed the file, so I'm shooting for the cover. But I would say, number one, we would be opposed to him reducing his income. Obviously, it's what he should have been making. He's in jail right now, and of course, the rearage is still sitting there. I understand it's a zero income, but he's there on drug charges and domestic violence charges and things of that nature. Nonetheless, to have a chance to,
according to his information, he was in jail at the time of the last hearing, and it does show that when an order went down to suspend his visitation, that he was actually appearing by Zoom from the Dixon County Jail on that occasion. So my belief is that clearly, if he was incarcerated, I understand your argument about the fact that he may have a willfully unemployed or underemployed, that you may have that argument to make because he's incarcerated, but it's pointless to set a child support amount when he is unable to do it. Mr. Thornberry, I'm not asking you to go into the facts of the case, but according to my review of the file, it appears that you are charged with 2 counts of attempted first-degree murder and then some drug possession charges. Is that, without telling me what happened, is that the charge that you're facing?
There's 3 counts of attempted second degree, 1 count of Schedule 1 drug possession, 2 counts of domestic, and then 1 count of resisting arrest.
All right. Well, let me just deal with this first and foremost. In my opinion, the suspension of your visitation has been properly heard by the court. You were given an opportunity to be present, and there's no basis to set aside that order because of the fact that you are currently incarcerated facing very serious charges. The order states that the suspension of your visitation would occur until such time as you are released from incarceration. Now, what that means is that as long as you're in jail, then you're not going to be able to see your children. Now, whether or not grandparents have a right to visit under a statute, that would be determined. The grandparents would have to file a motion for a visitation under the grandparents visitation statute, and that has not been done in this particular case at this point. But I cannot simply substitute your parents for you as far as the visitation goes. So under the circumstances, it would seem to me that the best thing I can tell you is I am going to suspend any order that sets his visitation or his child support at the current time based upon the fact that he is incarcerated and was incarcerated. I will suspend any operation of any child support order until such time as there can be a further hearing. And then that will give you an opportunity to have your client. I'm not back here until October, so it would be October before that portion can be heard. When it, again, not going into the facts of the case, but you have a lawyer, I assume, that's representing you on the criminal charges.
Yes,
Who is
Your Honor. I go back to court October 28th.
Roger Wayne.
Yes.
Roger.
Yes, Your Honor.
All right. When you need to contact Mr. Waynick and just, explain to him what's going on, but I don't want to have you testify about your criminal, where you'd be subject to a cross-examination. And so for that reason, I'm just going to put an order down that suspends the operation of the parenting plan as to the child support calculation based on the fact that you're incarcerated and have no income at the present time. Your motion to alter or amend or do away with these no contact order is respectfully denied based upon the fact that you're incarcerated and have, in my opinion, there's no basis upon which I can find that there's any change from the prior hearing. So you can renew that if you choose to by filing something in having it set in October. But if you want to have this child support issue heard in October, we can set it on a day in October. Give them a date, please.
We could do October 1st.
October 1st.
I'm fine on that day.
We're going to set it on October 1st for us to review both the visitation aspect as well as the child support issue. Okay.
Okay.
10:30
At 9.
at 9. Okay.
I'm
9
sorry.
o'clock.
You said October 22nd, is that correct?
No, October the 1st.
Okay.
That's the date. All right. Thank you.
If I'm correct, Judge, you're suspending basically the collection part of the child support, which is fine. We weren't.
Calculation of child support under that parenting plan is suspended based on the fact that he was not employed at the time that the order went down and has no income. So as a result of that, since he's still incarcerated, I think it's pointless to have that calculation in place. So we're granting your motion regarding calculation of child support until a hearing on October the 1st. Mr. Thornberry?
So the child support that's in arrears right now, is that going back from whenever the new plan went in place or from this day? Just for
I have found that the child support calculation was an error based on the fact that you were incarcerated at the time, and therefore it should not, but we'll deal with that on October the 1st.
Okay. Thank you very much, Your Honor. I hope you have a blessed day.
Thank you.
Thank you.
Call the next case.
2025 CV 49 Tommy King Jr. versus Megan King.
Good morning, Your Honor.
We skipped over the McDonald one, but that's because we did that. All right, this is the King versus King.
Yes, Your Honor, this is my case. Mr. King is present in the courtroom, sitting back here to my left. This is a divorce case. I see on the docket there's been a motion to continue. I didn't get a copy of that, but I see that it's in the file. I've looked at that this morning. So this is a divorce case that we filed. Mr. King's wife filed a divorce in Utah prior to our filing the divorce case here in Humphreys County. Mr. King has retained counsel in Utah and has challenged jurisdiction and venue there. There's a hearing set, I think in a couple of weeks, maybe July the 15th in Utah regarding that issue there. That's kind of where we are today. What's on the docket, other than the motion to continue, is my client's motion for some temporary parenting time. He's not seen his children in person since she left and took the children back to Utah. And so that's obviously something that he's desiring very much. So that's the status of the case, Your Honor.
Good morning, Your
Good
Honor.
morning.
Abigail Lang for the respondent. We're just asking that we continue this case until the motion to dismiss in Utah is decided upon. We believe that this case should be in Utah anyways, but Obviously, there's filing here for divorce here as well. My client filed in Utah in March. This was not filed, I believe, until May. So we're just asking to let us figure that out first before we have to maybe come down here for potential divorce and custody proceedings.
Well, obviously, it's kind of pointless in a sense for me to have a hearing if in fact Utah is going to assert jurisdiction and the facts support that finding. So it does seem to me that the more beneficial way of handling it, although I have had a case recently where we went forward with the hearing and I concluded that we did have jurisdiction, but that was essentially before me on a question that was raised by both parties as to whether or not this court had jurisdiction or the court in another state had jurisdiction. And after I heard the facts, I found that Tennessee had jurisdiction, and I put an order down to that effect. And the same request was made that California in that case had jurisdiction, and California court had a hearing, and I just simply made my findings and reset the matter for the California court to decide what they thought, and the California court found that Tennessee had jurisdiction and dismissed that action. So it seems to me that in this particular case, unless we're going to go forward today with a full hearing about the question of who has jurisdiction, that we can reset it after that July 15th date and let the Utah court make a determination, and then after that, we'll know where we are. So, it doesn't rob me of jurisdiction just because Utah has asserted that they have jurisdiction. So we'll see.
I'll supply everything to his attorney in Utah in case that court thinks it needs to speak.
There is a provision of the law that the Utah court can reach out to me to determine whether or not we can agree on which court has jurisdiction. So, and I've had those conversations on a number of other occasions, but in this particular case, I have not been contacted by the Utah judge to know that. So if there is a request for that, then I'll certainly be glad to do that.
And depending on what happens, I take it that I know you'll be back here in October, but you haven't heard anything related to this case. So
you can set it in front of any judge after that determination is made in the state of Utah. I don't have to hear it. So.
Okay. Thank you, Judge.
Thank you.
2024 CV 124, Michael Butler versus Lisa Butler.
Your Honor, this is Ms. Duke's motion to continue. I don't oppose it. We just need a date to reset it. Are you available the 14th of July?
I can't set anything up.
Okay.
That's all right.
Well, yeah.
You can't say anything else on.
That's when I had originally said it, and then they told me I could set it that day. I still had it down on my calendar. I had it on both.
Apparently, Judge Wallace has advised he cannot set anything else on that
day.
You need another date?
We do need another date just to set it in case we can't agree, but I think we'll probably be able to reach an agreement on it.
I don't think Ms. Roberts is available in August, the date that we have.
On the August dates, those are double dates, and I've already got everything set.
September 3rd.
You also have a Jones versus Jones case that's next, and you have a motion to continue in that.
I do.
Yes. And our only issue, and I don't know if Your Honor reviewed the motion, is the mental health of the minor children. It'd be the only reason that we would need to.
What's your
press
reason?
forward.
I haven't looked at the file yet. What's your reason for a continuance in that case?
Well, there was two reasons. Number one, inappropriate notice. We got it on Tuesday. Under the rules of civil procedure, we're entitled to 5 days notice, 5 working days notice. We were not provided 5 working days notice. I got it at 5:03, emailed to me. And again, just getting ready for it. Ms. Duke has made some accusations that are going to take this will be an all-day hearing.
If I may briefly respond, it was sent by certificate of service on the 18th, and so we complied with the rules of civil procedure, and then I also emailed it at 2:00 on the 23rd.
So
So
we
what
can mail in 3 days.
what are your issues regarding the urgency of it, Ms. Newt, in the Jones case?
A few of the minor children are gonna have to be in significant therapy based on the continued threats of the father and the bad mouthing of the mother and some things that he's doing to try to manipulate the children.
And that's
The
contested.
children are here if your honor needs to hear from them.
And again, the second reason is I had a deposition scheduled with Ms. Duke's law partner at 11 o'clock. But late Friday afternoon, Mr. Vandervoort filed a motion to continue, and we heard that in front of Judge Turnbow, and he granted the continuance. So that was the other reason for the continuance in my motion, but that resolved itself. But it did lead to the fact that I got this and had no time for preparation, and so we just need to continue.
What about, what about the 9th of July?
The 9th of July, I have Judge Lockhart Mashes in Dixon, and I have
I'm
Carbone
thinking
versus
is
Carbone.
give you a date for both of these that you may
Bugle.
have to hear it out of county because someone else will be here in July.
Judge, may I approach off of the video?
Mute this, please.
I don't like for everybody to know that I'm going out of town from the 5th through the 12th of July.
That was the reason we were moving Butler.
Yes.
18th.
18th of July.
This is all contingent upon your agreeing to hear it out of county because I'm going to be in Cheatham County, but I have that date available. And other than that, I could give you
As far as I know, I try to keep Fridays
I
open.
could give you the 29th.
The 29th, again, that's Judge Lockhart Mashes, Dixon Chancery, and I have a Bradford versus Bradford, and then a final hearing in a Crispin
Would
versus.
you rather hear this one on the 31st than just bump to the Bates case?
Now, I can do the 18th. I don't know. that one's due.
I have a matter that the Hickman County Court set, but I will file a motion to continue on that one. So I can do July the 18th. It's important that this be heard.
And we're doing Butler mediation on the 16th of July. So hopefully we can get a date on it. We'll just work together to get a date on it after the mediation.
All right, so we're gonna, at this point, we're gonna set the Jones case that Ms. Roberts is asking for a continuance on the 18th of July.
Yes, and can we admonish both of the parties to verify that nothing is to be said about this? That is our major issue. The kids are calling and crying, and we would assert that we've got text messages to back up everything that's been said in our motion.
I'm not gonna assume the facts in the case. Are the parents here, both sides?
They are.
Bring them up.
You will keep your hands out of your pockets, please.
Mr. and Ms. Jones, we're moving heaven and earth to get you a date to hear this motion that's been brought up, and there's been allegations that have been made by both sides about the situation. I'm not assuming that any of those facts are true, but what I'm going to tell you is this. I'm putting an order down today that you two are not to discuss this case with the minor children, period. Is there a guardian ad litem in this case?
I think we need one at this point, Judge.
I'm not opposed. I don't know that there's funds available to do it. It's a private case, but if we're never opposed to one, that's fine. We would just ask that both parties be ordered to make a deposit with that guardian ad litem up front.
Well, the reason the guardian ad litem is even being discussed is because of the fact that you've got minor children in the middle of this. You both may be fine people. You both may be good parents in your mind, and that's good. But my main concern and the main issue that I have in this case is to protect the best interest of the minor children. So if that causes me to have to come down hard on one of the two of you, so be it, because my interest is trying to protect the children. But by the same token, children are very perceptive and empathetic to their parents. And if they see one of their parents upset about something, then they naturally will, try to side with that parent, and they will naturally try to empathize with that parent. So let's try to shield the children from whatever's going on between the two of you. Let's don't involve the children And I say it in a very nice way, but I'm telling you, I'm ordering you not to involve these children and not to have the children influenced, not to discuss this case with you about this. If they have questions about it, you just tell them, honey, I can't discuss it with you because that mean old judge told me he put me in jail. You don't have to say it like that, but that's exactly what will happen. If I find out that you two have broken my order, then I'm going to put you in jail because I fully and firmly believe it is in the best interest of your children not to be put in the middle of this situation. Children are, used to having both parents. That's the home environment they had, and now that's blown up. Why wouldn't they be upset? I mean, that's a natural reaction to the fact that what they thought was their cocoon of protection and the home that they had is now no longer there because their parents can't get along and they're going to go through a divorce. But under the circumstances, you two can still make it okay for your children by protecting them from being exposed to all of the negativity that a divorce naturally brings about. Allegations may be made. Those allegations would have to be proven in court. I understand that children may be called to testify. I think that's a very regrettable, but sometimes a very necessary step to be taken. But that's the reason that I'm considering a guardian ad litem being appointed is the fact that the children need somebody to advocate on their behalf. Now, Mickey Furlong Smith is the one that I generally use in a lot of cases. I would simply suggest, since I've set this hearing for the 18th, that you two need to check with her and make sure she's available before. I know she's out of town right now.
She's in Chicago right now.
So it would be my opinion that you need to check with her and see if she's available on the 18th. If not, we need to get somebody else that is available.
Yes, sir.
And there are other individuals who can do that. Lynn Coffinberry is another one that we use on a regular basis. But let's find a guardian ad litem that's available on the 18th so that we can do this.
Yes, sir.
Where are we gonna hear this? Which courthouse?
Courtroom 5 in the Justice Center,
In Dix, okay.
Charlotte, Tennessee.
You just said you were in Cheatham, but where you're gonna be in Dix.
Right.
And again, some guidance, Your Honor, again, as you are well aware, children and their electronics to stay or something that I didn't necessarily grow up with, but punishment issues when you're taking electronics away from children because of misbehavior, whatever, does that include cell phones? And then escalates into, oh, you've taken my cell phone away from me.
My client doesn't have a problem with that at all.
So again,
But if she's explained to the children, if you've done something, Dad can take phone away. Yeah, absolutely.
Put it in the court order that one of the avenues of punishment. How old are these children?
they range.
We've got 16 and 11 right now.
Well,
There's a set of twins.
I'm of the opinion that if they are misbehaving and there's some reason to do that, taking their cell phones away is better than having a leather belt across the rear end like my father used to do with me. So I think that would be certainly permissible, and the children need to understand that that is not an abusive exercise of parental authority.
And go call the other one on somebody else's cell phone and say, somebody took my cell phone away and I'm
Just
in
put it in the
abuse.
court order that the court authorizes both parents to take the children's phones away if in an appropriate situation as parental discipline.
I will assert with the court that my client has absolutely no problem with that, but it was discovered that one of the children was confiding what was going on in Dad's home, and that's when the child's phone was taken away.
And that is highly disputed with some, and again, that's what they want you to believe, Judge, and I know you're not listening to that, and that's why I ask in a generic sense. I'm not trying to prime the pump that Ms. Duke is trying to do. It's disputed.
You two are good lawyers, but you are kind of like oil and water. And under the circumstances.
Good and bad. I realize that, Judge.
It is yin and yang, is that what you said? And there is some truth to that, whether you like it or not. But under the circumstances, I'm not assuming any of those facts are true. I'm trying to give you an opportunity to be heard where we can establish what the facts are. So let's just try to maintain the status quo and keep the children protected to the best of our ability until we have that hearing. All right. Thank you.
Thank you.
Thank you, Judge.
(2025) CV 37, Jackie Holland versus Robert Stevens.
Good morning. You are Jackie Lynette Holland.
Yes, sir.
Raise your right hand, let's place your under oath.
Do you solemnly swear or affirm that the testimony you shall not give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
You, Ms. Holland, you have filed a request for a divorce, and there's some issues with the complaint that you have filed because there's, on the second page of your complaint, there is a provision under paragraph 7 that states orders of protection and other orders, check the box that is true to you. And the first box that was checked is there is no order of protection. And then down below that was checked there and initialed, yes, there is an order of protection now in this court. It will stay in effect until the divorce judge changes it.
Okay, there's not an actual order of protection. There was an order attached to domestic violence, a no contact order attached, but not an actual order of protection.
Right. And there is no restraining order other than the statutory injunction. Is that correct?
Correct.
So your complaint contains certain statistical information. Is that information true and correct?
Yes, sir.
You've also filed with the court a marital dissolution agreement. That marital dissolution agreement purports to bear your signature and that of your husband's. Is that your signature?
Yes, sir.
Is that your husband's signature?
Yes, sir.
Do you believe that agreement fairly and equitably divides all your property and distributes all of your debts? You have provided me with a final decree. I need just a moment to look it over. An order of protection is not is a peculiar matter that is before the court under a specific statute. What you're talking about are bond conditions in a criminal case. I've changed that to indicate there's neither party has a current protective order, but bond conditions apply. I've signed your final decree. You can get a copy of it a little later in the morning, and you need to mail a copy of that to your now ex-husband. Thank you.
Twenty CV 64, James Johnson.
Morning, Mr. Johnson. Raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm that the testimony you shall not give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
You are James Glenn Johnson.
Yes.
Mr. Johnson, you've asked to change your name, and I need to ask you some statutorily required questions. Are you asking to change your name to avoid your just debts or creditors?
Yes.
Are you asking to change your name to avoid criminal prosecution?
Yes.
You have stated the reasons why you want to change your name to William Glenn Stevens Johnson. And is that reason the reason that you're asking to change your name?
William Glenn Stevens was my birth name, and I'm asking to reclaim that.
Okay. So do you want your new name to be William Glenn Stevens Johnson?
Yes.
All right.
And I attach the Johnson because I've got two signs, successive registered.
I understand.
Yes.
I'm going to ask you, if you will, to sign the order where it shows that you've approved that, and you signed the new name as well. So, I'm granting your name change, but you'll need to sign to approve that where the X is there.
So sign it
With your new name, William Stevens Glenn Johnson. William Glenn Stevens Johnson. All right, Mr. Johnson, I have granted your name change and signed your order. You can get a copy of it a little later in the morning once we've transmitted it over to the clerk's office, okay? All right, thank you.
2025 CV 69 regarding Kylie Ottenreed.
Good morning. Anyone who's going to testify, raise your right hand and be placed under oath.
Do you solemnly swear or affirm that the testimony you shall not give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
All right, this is petition to change the name of the minor child, is that correct?
Correct.
And you are the minor child? Don't look that minor to me. How old are you? 17. Okay, are you consenting to this name change? And who is the biological mother?
I am.
You've all been placed under oath. Do you testify that you're asking to change the name of your daughter to avoid any criminal prosecution or to avoid any payment of debts?
No.
All right. My understanding is that the last name is Alton-Reed, is that correct?
Ottenreed.
That she was given that name at birth, but that's not the biological father's name, is that correct? All right. And we're asking to change it to Kylie Nicole Elam. All right. And Ms. Elam, you are in agreement with that change, is that correct? And of course, the Wesley Alton-Reed has signed off on the agreement as well. So, all right, I will be glad to change your name. I always make that offer that I can change your name to anything you want it to be. If you want it to be Beyonce Elam or Taylor Swift Elam or anything like that. So you're happy with Kylie Nicole?
Yes.
You've submitted an order signed off on by both Wesley Alton-Reed and your mother, so I've signed your order. You can get a copy of it from the clerk.
Thank you.
Thank you. Thank you.
2025 CV 68 Madeline Forrester versus Timothy Whitfield.
I represent Mr. Whitfield. We're ready for a hearing.
All right. I mean,
He's gonna call the rest of the document.
Ms. Forrester, this is here today on an order of protection and a hearing to determine whether or not the order of protection should be issued for a longer period. There was an ex parte order of protection that was issued back on June the 2nd, and this hearing is designed to determine whether or not you want to have that order of protection extended for a longer period. Do you wish to have that extended?
Yes, sir.
All right, then we'll have to have a hearing. You have the right to an attorney to represent you since Mr. Whitfield is represented by counsel. Do you wish to hire a lawyer?
I'll hire one, yes, sir.
All right. Are you asking for this matter to be reset for you to hire a lawyer?
Yes, sir.
Ms. Roberts, she's asking to hire a lawyer, and I think it's probably in her right to do so. When's the next chancery date after the day?
Well, Your Honor, I'm not aware of any statute that grants her the right to extend the order of protection past the 15 days that it's done. So understanding that if she wants to hire an attorney, then we are not agreeing for the extension of the ex parte order of protection.
The ex parte order of protection is extended by statute for 15 days from the date of issuance, unless it's extended further. To extend it further, we would have to have a hearing, and that hearing would require testimony to be taken from you and from Mr. Whitfield. And under those circumstances, then you are putting yourself at the issue of that. resetting it means that this order that was issued ex parte would be expired by statute, but that you would still have the right to come back in on the next day I give you and to have a hearing to determine whether an order of protection should issue. You understand that?
Yes, sir.
And that would give you an opportunity to consult with an attorney and determine whether or not that should or should not be done.
Yes, sir.
And when's the next first available date?
So the lapse will be on the 15th, the 5th of July, Your Honor. The parties have a minor child. So
The first thing after the 5th is July 7th.
Let's see.
we have just taken Butler off July 7th. I've got to be here.
You have?
I will in the morning. I do. I have a Crichton, James, and a Harvey matter.
Right, we'll set it for July the 7th in front of Judge Wallace. You need to consult with an attorney as quickly as possible and have your attorney contact Ms. Roberts. Perhaps the two of you can arrive at, through your lawyers, can arrive at some sort of an agreement. Okay.
Yes, sir. I have a petition to establish paternity that will be served on her.
All right.
That is
And
out.
another reason you need to go ahead and hire yourself a lawyer as soon as possible.
Yes, sir.
All right, July 7th.
Yes, sir. Thank you.
Well, the next case.
2025 CV 58 Calvin Johns Jr. versus Amanda Hoffer.
This is here on pro se petition for an order of protection, and we have received a call. Well, the clerk's office has received a call from Mr. Johns, and he's indicated he could not come today and was advised that the case would probably be dismissed and he'd be taxed with a court cost if he didn't appear. Is Calvin Jones here? Clerk says that he sounded pretty high when he called, so I'm going to dismiss this case. He's taxed with a court cost. You are, I assume, not in jail over an order of protection. It's something else. All right. Case is dismissed. Thank you. Calls for tax to Mr. Johns. Let me fill this out. All right, come on, let's go.
2025 CV 61 Katie Story versus Robert Story.
Judge, I represent Mr. Story in this matter. It was reset from last week for a hearing for today, and we're ready for the court. I would anticipate maybe an hour or so. I can't get a lot for that today.
All right. Ms. Story, you are here today on the hearing for the order of protection that was issued.
Katie is my daughter. She is here. If you would like to speak with her.
It's not a question of whether I would like, I'm just interrupting you and I apologize. This is not a question of whether I want to or I would like to speak to your daughter. This is your case for you to try. You have brought a petition for order of protection and you have the right to call witnesses according to that petition. It is up to you to prove the allegations in your petition, and you can do that by calling witnesses and testifying yourself. But Mr. Hawley represents the defendant in the case, and he will be able to also call witnesses and cross-examine anyone who testifies. So if you have your daughter, how old is your daughter?
10.
You have a 10-year-old child here that you're going to put on the witness stand?
No, sir, Your Honor. I was told by the clerk's office that to bring her in case you wanted to speak to her in your chambers. And that if Mr. Hawley or Mr. Story objected, that then she would have to be brought in here.
Well, number one, as I said, it may be that the clerk was simply trying to say that if she's a witness, then she needs to come and that's the method by which she would be able to testify. It's not a question of whether I want to hear from her. Question, unlike some other instances, this is I cannot take sides. I can't try your case for you. I have to let you put on your proof and let you testify. Then Mr. Hawley can cross-examine you. Then if you want to call your 10-year-old daughter, then you have the right to do so. But the only method would be if they object to hearing from her in chambers, then it would have to be done in open court. And then Mr. Hawley can put on any proof he wishes to, and then we'll go from there. But at this point, obviously, I'm not going to be calling your daughter to testify. It will be up to you to make that decision. Let's, first of all, this is the last case, is that correct? All right, then are you ready to proceed on your petition for order of protection?
Yes, sir. I was also advised by the detective who, I've been told by both detectives that were involved in this case that I needed to get an order of protection for my daughter. But I was also told that I really didn't need to discuss the case because it could interfere with the investigation. So I'm kind of at a loss as to what I can and can't.
Do you
say.
and Mr. Story, are you married at the present time?
No.
Is there an order down regarding custody and visitation in a chancery court somewhere?
Yes.
Is that in this court?
No, sir.
Where is it?
That is in Hickman, and I went to the Hickman County Court first and was told that because the incident occurred here and because there was already an open investigation here, that it needed to be heard in this court.
Well, the only thing I can tell you is that if the basis for an order of protection is the fact that there are allegations made against Mr. Story regarding his conduct toward your daughter, then those allegations are going to have to be proven in court. And the only way to do that is to talk about the case if it's under investigation or not. Otherwise, you can choose to not pursue this order of protection and go back to, and consult an attorney and file something in the court where the custody order was down to try to get something addressed in that court rather than this court. But even then, the allegation would have to still nonetheless be discussed in order for a judge to make any sort of modification to the prior order. So it can't just be that, allegations are made and now we're going to change everything regarding a custody order. You have to be able to put those facts in the record, and they have to be tested by cross-examination, and then they would have the opportunity to take the stand and to testify themselves. If Mr. Story wants to take the stand in this hearing and put himself subject to cross-examination by you regarding these allegations, then anything he says can be used against him in the prosecution for the criminal case. And he would have to be advised of that fact before he testifies if there's a pending criminal investigation. What I'm going to do is I'm going to take a recess, and I would suggest that you might contact the officers that are involved in this investigation and tell them what's about to happen. I'm going to read through the file, and then when I come back, we'll take a recess for about 15 minutes and give you an opportunity to consult with those officers and determine whether or not you want to proceed with this proceeding or not. If we do, then we'll come back and we'll have the hearing, and I'll make such a ruling as I think is appropriate. But at this point, I'm going to read through the file and we'll give you an opportunity to consult with the state, with the district attorney's office or with the officers.
Okay.
We'll stand in recess for 15 minutes.
Just to court briefly, Judge, I've got the final decree. I've got some prior orders of protection that were unsuccessful. Hickman County Court wants to see those for your review.
I'm going to look at this file and this file only until we get into a hearing. You can then introduce whatever you want to. Yes.
All rise.
No response, Your Honor. Bond will be forfeited for non-appearance and reset at $100,000. Martin Ward. Good morning. You're Martin Ward. Speak up, please.
Yes.
And are you sick, Mr. Ward?
No, but I heard that COVID is my sister-in-law.
I can't, so since, if you're not sick, if you'll just pull it down while you're standing up here away from everybody, so I can see your face and hear
My
you.
sister-in-law and both of my sister-in-laws got COVID.
Okay.
And I've had it before, so I'm just
No, I appreciate that. And Mr. Ward, were you able to get someone hired?
not as of yet. I've interviewed 5 attorneys and I've decided on narrowing down to 2.
Who's that?
And both attorneys are required margin of payment.
Just tell me who it is.
Okay, it's Scott Minnick.
Mm-hmm.
And I'm trying to think of the last attorneys that I have that between that law firm and the same law firm, I'll pretty much go.
Okay, who's the other?
Scott Minnick and Benjamin Jeffries.
Okay. So if I give you one more reset, you think you'll be able to get one of them hired?
Probably need about 60 days.
Well, I only give 30-day resets, so let's do this. I'm gonna reset your case 30 more days. If you're making payments to one of them or saving up, that's fine. Make sure you give me that information when you come back. If for some reason it's not gonna work with those two, there's lots of other attorneys that have different payment plans, charge different amounts, contact some more, bring me that information. If you do get someone hired, just bring the reset notice that you get today to them and they'll tell you what to do, okay? All right, if you'll step in front of the clerk. Shaniqua Washington. Good morning, ma'am. You're Shaniqua Washington? And Miss Washington, did you get someone hired? I'm sorry? I need you to speak up. So you already hired him and paid him money on this case? So when you were here before, I told you you had to hire a lawyer, right? So he's not just gonna be your court-appointed lawyer down on this case, all right?
But he told me so you want me to hire him? But he told me to represent him with this case too.
Well, but you have to hire him to represent you. I'm not going to appoint him if you made bond. I gave you those rules when you were here before, right? So I need you to try to hire someone. It can be him, it can be whoever.
Okay.
If you can't afford to hire someone, you don't know that if you don't talk to some lawyers. That's why I ordered you to talk to at least 3. Because they all charge different amounts, they all have different payment plans. These are the same things I said last time.
That's my man had talked to me, told me it was going to be, but I don't see.
But if you didn't hire him on this case,
I understand.
then he's probably not gonna be here. And I don't know if he has something on, or does Joel have something on our docket today? But you need to talk to him about actually hiring him.
Okay.
Because I won't just appoint him because you were appointed down, because it's just different down here on this court. Okay. He's not. So he's not supposed to be on our docket anyway. So I'm gonna reset your case 30 days. Talk to him about hiring him, okay? If that works out, great. If it's not gonna work out hiring him, talk to some others, bring me those names and we'll discuss your options, okay? All right, step in front of the clerk. Donnell Coleman. Good morning. Are you Donnell Coleman? Ms. Coleman, were you able to get someone hired?
I'm not someone hired, but I did talk to 3 attorneys and I got the shortest quote, like during the period of my case pending. I had to quit one job. But the shortest quote that I got was $800 from a guy, because I spoke to Charles Ross, I spoke to Thomas Burbank, and it was a guy out of Galveston I was referred to named Eric Smotherman. And he quoted me, the cheapest one I got was $800. And so I told him that I would get back in touch with him because I wanted to start working again.
Okay.
I just got a new job.
You did? Okay.
And didn't go back on the pending case that I have now.
Okay.
And so I was moving forward with going to him since he gave me the cheapest quote.
Sure. So you think if I give you a little more time, you'll be able to maybe save up and get him hired?
Okay.
Okay, so thank you for talking to those lawyers. I'll give you another 30-day reset or so. If you get them hired, great. If for some reason that's not gonna work, talk to some others. As you can tell, they all have different payment plans and charge different amounts. Bring me those names and then we'll discuss your options. If you do get them hired, just bring that reset notice that you get today to him. He'll tell you what to do, okay? All right, step in front of the clerk. Yes, ma'am. Shadamon Mitchell. Shadamon Mitchell. Good morning. Good morning, you're Shadamon Mitchell?
Yes, ma'am.
And were you able to get someone hired?
Yes, ma'am.
Who'd you hire?
Benham and Jones.
Okay. Or which one?
I'm not sure. He said he would meet me here today. I'm sorry, this is my first time.
No, that's okay. So the lawyer's supposed to be here this morning?
Yes, ma'am.
Okay, so what I'm gonna do is just hold your case. You can either have a seat here in the courtroom or right outside the courtroom. If you'll let the bailiff know when they get here, or have him let the bailiff know, then we'll take care of what we can, okay? Don't leave until I'd say you can leave. Yes, please, that would be great. You can go back, you can step out. Zachary Turner. Good morning, sir. You're Zachary Turner? And Mr. Turner, were you able to get someone hired?
Not hired, but I'm leaning toward hiring Mr. Macon. I spoke to somebody at his firm, like Ms. Holmes, she quoted a little higher. I can kind of like 850 saved up, if they both want like 5,000 down. So,
Okay.
work on that.
And are you working?
Not at the moment, I just got my ID and stuff, as you can see, I'm on parole, I just got out, I'm just getting everything.
Sure. Okay. Since you did, do you want me to have you fill out, you want to fill out some, you've done what I asked you to. Do you want to fill out some paperwork to see if you qualify for a court-appointed lawyer?
Yes, ma'am.
All right, step in front of the clerk. She's going to give you that paperwork. Make sure you fill it out accurately and completely, and then I'll take a look at it.
Yes, ma'am.
Anthony Salvato. Okay. Good morning, sir. You Anthony Salvato? And this is a motion to revoke probation, Ms. Malfino?
Yes, ma'am, Judge. He is not clinically eligible for VA healthcare. However, he is participating fully in the U.S. Vets Houston program, which is a program for his mental health, housing, working, et cetera. I have corresponded multiple times with them. Is everything still going well?
It's awesome. This is the best thing that's ever happened to me.
Okay, and so I kind of talked to him about trying to stay involved in that as opposed to hiring necessarily a lawyer at this juncture.
Sure.
And I was wondering if the court would consider maybe allowing us to hold this motion for some short period of time, make sure he is well established in that program. I just hate to see this motion disrupt him from everything that he's doing with that. And I have received continual updated correspondence from them saying he is doing everything they've asked him.
And it looks like I have as well. They sent me a letter in May with the same thing, yeah. So let's do.
I can't tell you how well I'm doing.
That's great. It's when you find the right place that it's very helpful. So here's what I'll do. I'm just going to reset the case about 60 days based on what Ms. Malfino's telling me. Keep doing what you're doing. Stay in touch with probation, make sure they know everything that's going on, and then we'll see where we are in 60 days.
And I'll update Mr. Vuitton as well. He's aware.
Perfect.
Of probation.
Okay, thank you. Thank you, sir. Good luck.
Ashley, he still needs his.
Oh, yeah, we need you to sign your reset notice still. Dontrell Scott.
He's present, Counsel, Your Honor.
Good morning, Mr. Johnson.
Morning, Judge.
All right, so looks like you were here. This is his initial appearance, so you were just hired. I don't even see if we've gotten a a letter yet through e-file.
Everyone has it, I mean, it's.
It's probably on its way.
It is, Your Honor.
You just need some time then to get everything?
Yes, Judge.
So, Mr. Scott, thank you for taking care of hiring a lawyer. I'm going to reset about 30 days or so
Yes, Your
to
Honor.
give Mr. Johnson time to get the discovery in your case, and then we'll get an announcement the next court date.
Yes, ma'am.
All right?
Thank
Thank
you.
you. Yes, sir. Hey, Rife. Mr. Kimler. Kaylin Salzar is on my initial.
Yeah, I should have these files in there.
So she has hired you? Ms. Salzar? You're free to go, ma'am. Stay in touch with Mr. Kimler and your bondsman. They'll let you know when your next court date is.
Yes, ma'am, thank you.
Yes, sir. Yes, ma'am. If you'll just make a note of that, so we make sure we get that, that it comes through. Here's this one that qualified. Okay. Mr. Macon?
Yes, Your Honor.
You have Fernando Flores?
Yes, Your Honor. Your Honor, I have all the.
Hold on just a second. Is Ms. Maltino, did she step out?
She did, Judge. I'm this one.
All right, sir, you're Fernando Flores?
Yes, ma'am.
And this is 24-2354. Mr. Flores is charged with boating while intoxicated with a child passenger. Mr. Macon?
Yes, Your Honor, I have all the discovery and a plea offer and video. However, Mr. Flores has been working in Alabama, and our schedules just haven't worked.
Sorry.
However, he's only working there 2 more weeks, so a 30-day reset, I'll be ready to make an announcement.
Okay.
Publicly.
And it looks like you were just hired in May. So what I'll do, Mr. Flores, is reset your case about 30 days. Regardless of work, you need to make an appointment visit with Mr. Macon before that next court date, okay? And then we'll see if we can get an announcement. All right, you're free to go. Thank you. Mr. Wilkerson, you have Kimberly Scott sentencing.
Yes, Your Honor, I also have one, well, I'll go ahead and take care of this one.
Okay. Kimberly Scott. This is Mr. Hoffpowers. Good morning, ma'am. You're Kimberly Scott. And Ms. Scott was previously in court, entered a plea of guilty in cause number 250470 to the state jail felony offense of abandoning or endangering a child. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Are there any additions or corrections?
Nothing from the defendant.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 2 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have the conviction on your record. You're not a convicted felon. And at the end of the probation period, if you successfully complete it, the case will be dismissed. You'll never have a conviction on your record. The other side to that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and then you could be sentenced to the state jail prison for up to 2 years. Do you understand? And it sounds like everything has gone well. You did everything you were supposed to with CPS. Kids are back with you. We talked about this, I think, before, and obviously I've it sounds like this is something that was out of character and that we shouldn't expect to happen again. So, all right, I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat in the courtroom. When probation's ready to go over your paperwork, she'll call you back up to her desk, okay? All right, good luck to you, ma'am. And did you need some time on Paul Castillo?
Yes, Your Honor.
I'll hold it. Mr. Rojas, you have a sentencing on Chad Smith. It's a sentencing on Chad Smith. Okay.
That mystery is going to be dismissed this morning.
Okay. Good morning, sir. Are you Chad Smith?
Yes, ma'am.
And Mr. Smith was previously in court in cause number 242309, entered a plea of guilty to the third-degree felony offense of evading arrest or detention with the use of a vehicle. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Yes, sir.
Are there any additions or corrections?
Just an update, Judge. Page 3 shows that Mr. Smith is unemployed. He tells me that he's been working for about 3 weeks at Post Contractors. He's a foreman out there, making about $21 an hour.
So I know y'all know what my concern is here, that there were 2 felony probations just in the last 5 years that were revoked in the last 3 years. 2 different probations, one here and one in Brazoria County. So I don't have good warm fuzzies about you being successful on another probation.
Can I say something?
Mm-hmm.
That was a whole another life ago. I've corrected my life. I've been sober for 3 years now. I've been focusing on nothing but working. Disobeying arrest was actually a discrepancy that I didn't pull over fast enough with the officer. And I haven't been living that way in over 3 years now. So if you give me a chance, I'll show you that I can do it.
Okay. Mr. Smith, any reasons not to go forward then? All right, so I'm going to give you this opportunity. I do hope you take advantage of it and that you really have made those changes. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a motor vehicle. Sentence you in accordance with the agreement you made to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm suspending that. You'll be placed on probation for 6 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, then as you know, for all practical purposes, your case here in court is over. You'll be able to serve that sentence while you're out on probation. The other side, however, in this case, is you've already agreed to a 10-year sentence. So if you violate your probation, you have that 10-year sentence hanging over your head. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. You've probably already received that, but I'm required to read it. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. And it's my understanding there, take him down there, and something's gonna happen on that misdemeanor this morning.
We're gonna dismiss it, Judge, so.
Okay.
I can walk down and see if I can find which court is it.
I think it's County Court 3.
I can walk down there.
Okay. Okay, as soon as, so if we can just hold him, if you'll come back and let us know as soon as that's signed, so you don't have to get transported or anything like that. Okay, yes, sir. And Carnell Beard, Mr. Rojas? Good morning, sir. You're Carnell Beard?
Yes, ma'am.
And this is 242414. Mr. Beard's charged with collision involving serious bodily injury. And Mr. Rojas, what's the announcement?
Judge, we do have an offer in this case. I asked for another reset. Mr. Beard wants to give me some documentation that I can forward up to Ms. Malpino that hopefully will help us out.
Okay.
To get a better offer.
Any issues? All right, Mr. Beard, I'm going to reset your case about 30 days. Make sure you get that information to Mr. Rojas quickly so he has time to get it to Ms. Malfino and they can visit about it before that next court date, okay?
Yes, ma'am.
All right, you're free to go.
Thank you.
Yes, sir. Mr. Jones, come back up, please, sir. So you only tested positive for amphetamines, and it looks like you have a prescription, but I want to go through real quick. Hold on, let me read this police report real quick about your last arrest. All right, so Mr. Jones, obviously, hold on a second, you're on probation for theft of a firearm. You've been arrested, what, just last week, week before last, and were able, I guess, did you make a bond in the new case?
Yes, ma'am.
Because you're on probation for the felony offense of theft of a firearm, and because you were arrested in a vehicle that looks like, allegedly, obviously you've not been charged with it, but there was marijuana in the car near the seat where you were sitting. It smelled like y'all had been smoking marijuana, and there was a gun in the glove box where you were sitting. So I'm going to find that the bond that I set in the motion to revoke your probation case is not in the best interest of our community. I'm going to find that because you've been arrested while you were on that bond, that it is appropriate for me to raise that bond. And at this time, I'm raising your bond to $200,000. You can go back with the bailiff. Hand it to the bailiff.
I'm trying.
You gotta try harder than being in a car with a gun and marijuana while you're on probation. You've got a motion to revoke your probation. Go with the bailiff. We'll figure it out. We'll get you a lawyer appointed and we'll figure it out. Trying to go into the morning, which is probably the best place, but you're on probation, you can't go anywhere. Yes, on the MTRP, just on the MTRP at this time. Yes. This one qualifies. Let's see, Mr. Johnson, are you visiting on Ramona Houston?
Yes, Your Honor, actually.
Okay, I'll hold it. Take care of it as soon as it's ready. Thank you, sir. And then, Mr. Kimler, you have James Wheeler sentencing.
Still three. No, that's
There was no agreement, correct?
consent agreement.
Good morning. Are you James Calvin Wheeler?
Yes, ma'am.
And Mr. Wheeler was previously in court. This is 23-1800. Mr. Wheeler's on probation for fraudulent use or possession of identifying information, a state jail felony. There was a motion to revoke filed, pled true to all of the allegations in that motion to revoke. And what is the announcement?
Well, Judge, this is,
I mean, not what's the announcement, what is, I guess, what's your position?
after reviewing the
Good morning, sir.
recommendation from probation and some of the documentation that's been provided, I'm in agreement with continuing on probation. I'll note that the recommendation from probation made note that where'd it go? That he's demonstrated his ability to stay sober, that the CPS involvement, they even noted his exceptional cooperation and things like that. So based on that, I don't have a problem with continuing on probation at this point, Your Honor, if the court should agree.
So what kind of treatment are you receiving now? Have you completed what you had started with?
I completed everything, I've done the pregnant house, and then I was with the CPS, and then we did, much more. Now, I'm full-time working, 50 hours a week. So pretty much just all I'm doing is working and sleeping.
Can I ask probation a quick question?
Sure, please.
Are there any programs that you think he needs moving forward, or anything that would help him?
I just want to make sure we maintain sobriety.
Yes, he needs to continue doing AA.
So, Mr. Wheeler, part of what concerned me here was that for some amount of time, you didn't turn yourself in, you absconded, and I understand that you went and did treatment, but you don't get to make those decisions on your own when you're on probation. So if a motion gets filed, if there's an administrative hearing, whatever it is, if there's a warrant for your arrest for some reason, you don't get to say, well, I'm going to go run and go do treatment, which is great, and I'm glad you did. But if something happens in the future and you relapse and you decide, well, I'm going to go do what I need to do and not what probation's telling me to do, we're not going to be having the same conversation. Okay, so based on the pre-sentence report and how you're doing, I am going to find that you entered your pleas of true to all of the counts freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, but I'm not going to do that. I'm going to continue you on probation, order that you continue doing everything that probation says you need to, all the classes. If there's some issue and they feel like you need more treatment and they say you need to go to JCDI or they say you need something inpatient, it will be required, or you will be back in here looking at that 2-year term that you already have agreed to. Do you understand? You are substantially behind in your fees. Now that you're working, you need to make a concerted effort to get those paid. At least start whittling down how much you are behind. Anything else, Mr. Nichols?
I think that covers it, Your Honor.
Okay, so I'm going to hand you actually, if y'all will sign that and just give them the bottom page. That's just showing that this wasn't an agreement. You have some rights. You can talk to Mr. Kimler about that. Just stay in touch, obviously, with your probation officer and continue doing hopefully as well as you have been.
Yes, ma'am.
And you can just give him the back page. Mr. Kimler, please.
Thank you, Your Honor.
Thank you. Thank you, sir.
Zachary Turner.
Mr. Parker, you have Timothy Horace. Anna, I don't have anything on here, do I? Should I have? Oh, okay, I just thought you had some over there. I feel like I saw one and now it's blank. I thought there was one on here. But I have nothing now, it's all just blank. Good morning, are you Timothy Horace Jr.? And this is 242259. Mr. Horace is charged with obstruction or retaliation. Mr. Parker?
We have plea paper.
Oh, this is, yeah, mine's, everything just went away on mine. Do you want me to, is there a way for me to, refresh or something?
No, ma'am, because I don't see it.
Y'all just have a seat for a minute. We're gonna find your paperwork hopefully somewhere and y'all won't have to do it again. Just have a seat in the courtroom for a few minutes.
I know she sent it, and she got it, but she paid for it.
Well, there was something here a minute ago on mine and now it's gone.
That's why I called it up.
Yeah,
Now it's.
gone. Let's take care of your sentencing on Richard Rogers, Mr. Parker. I know, just go on. Cause I knew I saw something and she's been swearing some people in. Good morning, are you Richard Parker Rogers?
Yes, ma'am.
And in 242336, Mr. Rogers was previously in court, entered a plea of guilty to driving while intoxicated, third or more, and received the pre-sentence report. Is there any, has everyone had an opportunity to review that report?
We have, Your Honor. Yes.
Are there any additions or corrections?
No, Your Honor, not from the state. Only thing we're asking, Judge, is that he be allowed to do this 10 days on weekends. He has a job. I'm actually related to him, and he is on his own. He went to rehab, and through the help of his mother, and has continued to do aftercare, and the family's been very pleased with what he's done, and he's
Good.
made arrangements with his job that it won't affect his job, so he would do the
To do
10 days on
weekends.
weekends.
Any issue with that? And do you have a vehicle?
Yes, ma'am.
And does it have the ignition interlock device in it?
Yes, ma'am.
Okay. And you know you can't drive any other vehicle other than that one that has that in it, right?
Yes, ma'am.
Okay, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement to a term of 10 years, excuse me, in the institutional division of the Texas Department of Corrections, but suspend that and place you on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That does include that 10 days upfront time that will start this coming Friday, July 4th at 6 p.m. And then you're going to go every weekend until you satisfy those 10 days. It's very important that you're on time. You get there at 6 o'clock. You're not late. It's very important that you're sober when you get there. A lot of people think that they're going to show up drunk or whatever and sleep it off over the weekend. It's a terrible idea because you'll be in violation of your probation very quickly. You'll have to follow all of the other rules and conditions of probation. If you do that, then this is a great opportunity because for all practical purposes, your case here in court is over and you'll be able to serve that sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you have agreed to a 10-year sentence in prison. You can be brought back into court, your probation revoked, and you could be facing that 10-year sentence. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. You need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir.
Thank you.
see one thing came through, a plea bargain rejection. But we don't know. Oh, well, try. Okay. Okay. Mm-hmm. I've never had this where something was showing up and then it's just gone down here. I haven't.
Paper is a lot simpler. It doesn't just go away when you're signing it.
I know, right? See, Mr. Lewis, you have Justin Wallace.
Yes, ma'am.
I do have that one on here. Morning.
Morning.
All right, sir, you Justin Dwayne Wallace, and this is 24-1590. Mr. Wallace, you're charged with a second-degree felony offense of indecency with a child by sexual contact from October 1st of 2021. Your indictment alleges you were previously convicted of possession of a controlled substance, a second-degree felony, March 21st of 2006, in two cases on that same day. What that means is that if you go to trial in this case and you're found guilty, your punishment would be enhanced to that of a first-degree felony, which is between 5 years and up to 99 years or life in prison. Do you understand? And I have a plea bargain rejection that has your signature on it with Mr. Lewis's here that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a cap of 15 years in prison. And I know Mr. Lewis has gone over that, but what that means is that if you wanted to take that deal, you would be leaving your punishment up to me. And if I followed the agreement, I could not give you more than 15 years. I could give you 15, I can give you less, I can consider probation. It would all depend on the information that was brought to me at a sentencing hearing. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that?
Yes, ma'am, I do.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. And so, Mr. Wallace, Mr. Lewis has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him today. I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
I want to keep it.
Okay, that's fine. So Mr. Lewis will remain your attorney. We'll set it on the trial docket and he'll begin preparation for trial. And we've already got CPS records back and everything that we were waiting on, correct?
Right, that's what we're waiting on. Just
Okay,
we got it.
perfect. All right, we'll get it set for trial. Stay in touch with Mr. Lewis. He'll let you know when you need to be back. Mr. Lewis, on Jaron Crane, is that one that you had paperwork working on or no?
No.
All right, so Jaron or Jerron Crane?
May go off the record.
Sure, Jerron Crane. He's not coming? Okay, have y'all heard from him? Anything? Yeah, come on up. What did he tell you?
Well, I be blowing him on texting, so I've been I kind of took a conclusion. I'm trying to do like a withdrawal with him.
Okay.
Because it's like he's coming from Houston, but it's like.
He's not coming.
I know about the payment, but it's like, I only got the discovery. You know what I mean? I don't.
Yeah. All right.
So I was gonna talk to you about, see if I can get through there and send to.
Yep. So what I'll do is reset your case about 30 days. Make sure you start talking to other attorneys soon. Don't wait to the last minute, because if you do get someone else hired, they'll need to file the appropriate paperwork to substitute in, okay?
Correct. I had got the 3 from last time we talked, but I had hired him prior, and it was like 1800, but it's like you worry about the payment, which ain't a problem, but it's like, I don't even know what's going on.
Sure. Well, okay, just, you'll get about 30 days or so. He's still your attorney. Stay in touch with your bondsman. They'll let you know when your next court date is. Okay?
Yes,
All right,
ma'am.
you're free to go.
The bondsman's gonna let me know. Like,
Yes,
that's what
keep in touch with your bondsman for sure each week like you're supposed to, and they'll let you know when your court date is.
Yes, ma'am. Thank
Okay, yes, sir. See if we see Mr. Burbank and Mr. Adams.
You were here earlier.
Okay,
Ramona Houston.
Mr. Okay,
Judge,
yes,
on Ms. Houston's case with Mr. Johnson, so you know what we're doing. You'll note the age and offense date. It's a 5-year-old DWI.
Okay.
I'm doing a reduction to a Class A. She did 5 days in jail when she was arrested.
Okay.
She's currently enrolled in a veterans treatment program in
Okay.
Houston. So I'm trying not to interfere with that, just have her continue that, with this being 5 years old.
Yeah.
That's why it's a
And I
reduction
think-
in the light sense.
technically I think giving credit on that isn't what we are supposed to do, but if there's nobody that argues that, then that's fine with me if you're okay with that. Okay, as soon as it comes through, I'll take care of that. Let's see, Mr. Wilkerson, you've got Paul Hernandez Castillo.
Yes, Your Honor. Good weekend.
I did, how about you?
It was pretty good. Got to rest.
That's always nice.
Yes.
Good morning, are you Paul Hernandez Castillo? And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Castillo, cause number 250187, you're charged with the state jail felony offense of solicitation of prostitution from December 19th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes.
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year deferred adjudicated probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. Castillo is not competent?
There is not.
And Mr. Hoffpower, since this is a state jail, is there any history or?
No history, Your Honor, I don't mind. Yes, sir.
Okay, so then, Mr. Castillo, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. I'm going to waive the pre-sentence report. I'm going to follow the agreement that you made with the district attorney, defer all proceedings for a period of 2 years. You'll be placed on probation. You're ordered to pay the fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation, if you successfully complete it, the case will be dismissed and you will never have a felony conviction. The other side to that is if you violate any condition of probation, you can be brought back into court, you could be found guilty of the offense, and you could be sentenced to the state jail prison for up to 2 years. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You just need to have a seat here in the courtroom. There's a lady sitting at that desk right there with probation. She's going to call you up to go over your paperwork.
Has to
when she's
be
ready,
analyzed.
Okay? All right, good luck to you,
Full.
sir. Mr. Johnson, on Ramona Houston,
Ms. Houston, Your Honor.
good morning, ma'am. You're Ramona Houston?
Yes, ma'am.
Let me get this pulled up. And Mr. Johnson, will she waive the formal reading of the indictment?
We will, Your Honor.
And it looks like the state is proceeding on the lesser included offense of a Class A misdemeanor DWI. Is that correct?
Yes, Your Honor.
Let me get it. All right, Ms. Houston, in cause number 21-36380, again, the state's elected to proceed in the lesser included offense of a Class A misdemeanor DWI, and that would be a DWI second or Class A
Second.
because of the amount?
A second.
A second. And that is from October 4th of 2020. It alleges that you were previously convicted of driving while intoxicated March 15th of 2013. And how do you plead to that charge?
Guilty.
And is that prior offense true? Conviction. Are you entering your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you
Yes,
with?
ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Johnson?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And the agreement is for 5 days in jail and that you have credit for that, is that correct?
Yes, Your Honor, I checked. She served 5 days.
Okay.
She was initially arrested.
State tenders number 1.
Without objection, Your Honor.
It's admitted. Is there any evidence that Ms. Houston is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of driving while intoxicated. Sentence you in accordance with your agreement to a term of 5 days in the Jefferson County Jail. You will get credit on that sentence for the time that you were in there before for those 5 days. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. And Mr. Nichols had previously mentioned, it sounds like this is obviously an old case for whatever reason. You're doing great, and I think that's the reason for this plea agreement.
And she's participating in Veterans Treatment Program in Houston, Your Honor, and our wish is that that not get interrupted, that she continue her progress there.
Perfect. Good luck to you, ma'am.
Thank you.
Thank you, Mr.
Thank you, Your
Johnson.
Honor.
Mr. Johnson, do you have your discovery certification? Ma'am, don't leave yet. If y'all look at that sign real quick, Mr. Nichols will.
3914, yeah.
Thank you. Mr. Lewis, on Deshauna Bass. I heard the sigh from over here. You giving Mr. Cohen a hard time this morning?
He needs it. I don't even know if I can tell you need it.
Deshauna Bass.
Yes. We had.
Take care. Good morning. Are you Deshauna Bass? And Ms. Bass is charged with assault on a peace officer in 24-2316. And what's the announcement?
Judge, I was talking to Mr. Copeland, we've been trying to come to a resolution on this one, and he's made us an offer on this case. And I'm talking to my client, I think it may be best before we either accept that offer or set it for trial, if I get her in the office so she can look at the rest of the body cams herself
Okay,
to make that decision.
all right,
And then we'll definitely be ready to move the case by the time we come back.
all right. Any issue, Mr. Coleman?
No objection.
All right, so Ms. Bass, I'm gonna reset your case about 30 days. Make sure you call soon and make an appointment so you have plenty of time to go in and visit with Mr. Lewis about your case, watch any videos, look at the discovery he has, and then talk about your options, and we'll get an announcement at the next court date. Okay? Thank you. Ms. Holmes on Isaac Talley.
Yes, Your Honor.
Did you ever find?
I'll read the paperwork.
Y'all redid it? Okay.
And am I can see that it went all the way to you and
Good morning. Are you Isaac Talley? And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Talley, in 24-1997, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from August 26th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you sign these, did you go over them with Ms. Holmes? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you reached is for a 3-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Talley is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation department can do a pre-sentence report. That'll just give me more information about you, your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there, okay? All right, we'll see y'all back at sentencing.
Thank you.
Ms. Holmes, you have a sentencing on Devontae Savoy.
Yes, Your Honor.
Devontae Savoy.
He's outside his grandmother.
I'm gonna test him before you. Good morning, you're Devontae Savoy. Mr. Savoy, before we go forward with your sentencing, I'm gonna have you tested to see if there's anything in your system today. Have a seat up there. Okay, I want to.
Cause number 23-41596, the state of Texas versus Daniel Clayton Raleigh, who's present with his attorney, Mr. Burbank, and the state's attorneys. There we go. Yeah. Okay. Go ahead. Who? Herrera?
Barrera.
Can I take this person on board, Howard?
Yes, you may. Go ahead.
Good morning.
Good morning.
Before we go into the workings of the Scram, I need to ask you some questions, ma'am.
Okay.
What is your educational background? Where did you go to school?
Some college.
Okay, what do you mean some college? Where did you go
I
to?
did about a year in community college.
Okay, it was out in Houston?
Yes.
Okay, and did you receive a degree?
No.
Okay, in reference to the Scram, did you have you ever done any studies in reference to the Scram and how it internally works or how it's been put together?
I've had some training through AMS, which is the makers of this.
Okay, and what type of training did you have?
I had training as far as like installing the equipment, reading reports,
Okay.
things like that.
Now, in reference to the internal of the Scram and how those reports are generated, do you have any knowledge of the workings of the inside of the Scram in order to produce those reports?
So the reporting is received to us from AMS.
Ma'am, my question is, what training and experience have you had in reference to the inner workings of the Scram device? In reference to how it takes the sample and how it formulates an opinion. Were you ever involved in anything like that? The internal workings?
Not necessarily.
Okay. You were.
Not necessarily. What does that mean?
So AMS will, well, let me go back. So at the beginning, they will train us on how the bracelet works. But as far as like the internals, all that is done through AMS. They provide their reporting to us and then we provide the reporting to the agency.
So it's safe to say that you were taught how to put the device on an individual, correct?
Correct.
You were taught how to send whatever information you need back to the corporation or the company, correct, for analysis?
Yes.
And then they come back and give you a report.
That's
Is
correct.
that just in simplest ways?
That's correct.
But you don't know how they determine what information is put on that report. And what I mean is the results. You don't have anything to do with that.
No.
You don't have any knowledge whatsoever of how they even, the calculations and the formulas used in order to say, yes, there's a positive or there's a negative in the reporting. Is that fair to say?
Okay. It's done through AMS.
You just receive a report from a third individual that you don't even know who actually does the analysis, but you just receive information from a third party in a report.
That's correct.
And you've never done any writings, research, studies in reference to how this actual, I guess, calculation is done, like the analysis and stuff like that, correct?
Correct.
This time, Your Honor, I am going to object to any type of findings from this witness that she is respectfully not qualified, but if she wants to testify to putting it on and taking it off and submitting the information, we are challenging the actual results of the Scram device.
Okay. Any response from the staff?
Your Honor, she's perfectly capable of reading the reports and what she says. I brought her as a custodian of record to get the reports in. That she can tell if the reports are accurate, if they're good reports. She doesn't need to be a member of AMS. She's gone through all of the training. She works with the monitoring business. Just because she doesn't have the actual internal minute workings of the device does not mean that she can't testify to the report or to the fact that she's a custodian of record for the reports to be admitted into evidence.
And that's, if I may reply, Judge, is the information in the reports that are hearsay and that she does not, she has a report but it is the person that prepared that report and the analysis that was done for the reliability of the information that was given to her that we object to. Not that she's a custodian or she has a record.
Anything else?
No,
The court is going to refer the parties to State's Exhibit 1 that was admitted on June 6th in this court hearing.
I didn't, no, it was not admitted.
It's dated that and it's in the
No,
record.
It was shown as an exhibit. I made an objection. You sustained my objection.
That's why she's here.
Sir?
That's why she's here today. Is those objections, he objected we didn't have the custodian of the records. We brought her. Today's objection is it's a scientific objection.
It's always been a scientific objection, Judge.
The record will speak for itself what happened on June 6th. I was here, I recall what was said. If we need clarity, we can look back at the record.
Okay. What he seems, Mr. Burbank is objecting to, at least in this hearing, is the methodology of how it works, which is clearly described in this report called State's Exhibit 1. She hasn't testified to any of that. It's all in here. She is testifying to, like a blood draw, how a sample is taken and what happens with the sample to ensure that the sample is a valid sample that can be tested. But the science behind the testing, not the actual engineering of the carrying it out, but the science of how testing is valid and is a science that we can rely on for its results, or really twofold. I mean, the science behind it, somebody has to have information and the ability to say, this is the way it works. And then number two, we took a sample and it was analyzed in a fashion that is accepted by science and is deemed believable by science and history and training, based upon proper training, if it's carried out right. But those are always the two parts of whether it's blood, urine, breath. Those have always been the bases. It's what testing is theoretically accepted, that is based on a science. And then number two, is the actual application of that theory accepted by courts and experts, carried out in a manner that does not cause the testing procedure to be questioned, or it proves its validity. But he keeps objecting to the theory behind it, which is right here in this exhibit. I believe she's going to testify to how the theory is applied in a test and how that test works its way through the system, normal and customary, in a way that's acceptable in courts, and shows that and proves that it's a valid result. I think that's what she's got, is the second part. He's objecting to, she doesn't know how the science works in the first place for it to be accepted. But it's right here in State's Exhibit 1. Is that right?
She doesn't have the knowledge of.
I mean, that's what you're objecting to
the theory and the results. And the court did make a good analysis. It's like a blood draw for DWI or an alcohol test result, BAC, that they have to have someone that has knowledge in reference to the testing, in reference to the results that they have in the report. And all she's going to testify to is the results that she was given.
Often the same person takes care of it. It takes care of both issues. He's objecting to what's in State's Exhibit 1.
That is
because he's contending she doesn't have that knowledge that supports.
Judge, it's just today's objection. The last time we were here, he was objecting because we didn't have the person here to support the records.
Well,
we brought the person.
Who was here last time? Was there an individual here?
We could not.
Oh, okay. He's entitled to do it, but he's entitled to object, but he's got a point on it. We've got to have the proving of the science behind it. And then the procedural methodology.
Judge, had Mr. Burbank raised that objection before today,
I understand.
we would.
You're surprised. Okay.
Yes, that's what I'm saying. And frankly, Judge, if I can be honest with the court here, whenever we deal with any individual that's on bond, normally it's about getting the results before you, and we've just been blocked by Mr. Burbank to even let you see the reports. We gave him all the reports that shows not only one violation, but so many violations that instead of just conceding that his client has an issue, the argument today is they don't have the proof about all these violations. That's incredibly frustrating because whenever we deal with people that are on bond and they come in and they have a test in court, Your Honor accepts that.
I understand.
When people have a blood test, you accept that. We have a Scram that we've ordered. These are the results. We're trying to tender the results. We can't even get past the point to let you see
I can understand your frustration. Most times the objection like this is not made, but he's representing his client vigorously, like he's required to do in his way. I mean, you can't, I'm not going to say, nope, sorry, you can't object. I'm not going to do that. He's entitled to represent his client, and you're surprised because we can put her testimony on while we're here, okay? And the court will end up having to defer unless something happens during this testimony. Defer a finding and I will give the state an opportunity to present more evidence to support the record on the theory behind Scram and why it is generally accepted as a science. Go ahead.
All right. Are you a custodian of records?
Yes,
How are the Scram records kept?
in the course of our business.
How frequently are the reports updated?
They're not so much updated. However, POs will receive a monthly report if there's no violations. If there is a violation, they'll get it within 2 days or so.
I'm going to show you what has been marked as State's Exhibit number 3. Is this a client report?
Yes.
And does it list all of the days that this individual was running the Scram device?
Yes, up until I believe June the 3rd.
So that was the last.
This year.
This year,
Right.
yes.
So that was the last time that the report was updated for this client.
I believe that's the last time he reported to download the data with an RMS technician.
Okay, so how does that work, the downloading of that?
We have a technician that comes to Beaumont every 2 weeks. I think he is to, report every 2 weeks to do, download. And that's when, we'll get all the data from the bracelet.
Okay, so this report is generated, or the days are generated every time the device is downloaded.
That's correct.
Now, as part of these readings, does it mention how many times the device does a reading?
It does.
How many times does a device generally read an individual?
I believe it's between 47 to about 50 readings per day. That's what I've seen.
Do you know why it does that?
Objection, Your Honor. Again, it is not within her scope.
Well, let's find out. It calls for a yes or no answer. Does it? Then we'll see what the answer is, and then you can object. Go ahead.
Do you know why it does that many readings?
Every 30 minutes, it'll take a reading for alcohol. So it can vary between, like I said, 47 and 50.
Now, besides the number of readings on those dates, what other things does it tell you about every individual day?
It'll have, if there's any alcohol readings, it'll show that as well. I believe that's all that's on the report.
Okay, so it gives positives, does it give tamper alerts?
Yes, it does.
And then does it give equipment alerts?
Yes, it declines to come in for maintenance or to swap out the bracelet, it'll let us.
Okay, so a positive would be the device detecting an amount of alcohol.
That's correct.
What do you know what the lowest amount of alcohol that the device will detect?
Your Honor, again, I'm going to object in reference to the.
Let her answer first, and then we'll see where the answer takes us, and then you can object. It's a yes or no answer, then object.
Well,
But
that question wasn't, but okay.
yes, it was. Do you know? Was
You know what?
No, do you know the lowest amount of alcohol that the device will detect?
I believe that the baseline starts at 0.0008.
Again, Your Honor, I believe.
how do you know that?
I'm drawing a blank, so I'm pretty sure it's 0.0008.
No, but I mean, you didn't just dream that up.
Oh, no.
Okay, I was saying.
It's on the report and it's been it's part of our training. I just don't remember the exact number.
But you do learn in part of your training the lowest number that the device will detect.
Yes, that's right.
Did you also learn as part of your training what it takes to tamper with the device?
Yes.
Okay. How does an individual tamper with one of these devices?
They can place anything in between their ankle monitor and the scan. They can remove it. Anything blocking the device will show as a tamper.
May I have state's exhibit number 1? Showing you would have been marked as state's exhibit 1, 2, 3, and 4. Are these records that your company has provided the state?
Yes.
And are all of these records kept in your normal course of business?
Yes.
And are all of these reports made close in time to when the event actually?
Yes.
State exhibit number 1 appears to be a non-compliance report. Is that correct?
Yes.
What is a non-compliance?
A non-compliance report, it's a, confirmed violation. That's the reporting that we send to the POs and we found is a confirmed violation, whether it's a tamper or an alcohol consumption event.
So so you say confirmed, how is it a tamper or a positive confirmed?
Objection, Your Honor. Reference to she's going into how they confirm whether it's been tampered or not with.
Do you know the answer to that?
Yes.
Okay, by your experience and training?
Yes.
Overruled.
AMS has a group of data analysts that will, take a look at all the readings. And they will determine whether it's an actual violation or not. Once it's been confirmed that it is a violation, they'll send a report to us. And then we forward that report to the agencies.
Again, Judge, it's based on hearsay and a third party.
Okay.
That you
Anything else?
testified to.
Overruled. Custodian records primarily testifies from hearsay. The key is what is the extent of her training and experience, and this court is allowing her to testify to those matters. Go ahead.
Are you trained in reading the reports that are sent?
Yes.
I'm flipping to page 4 of this report. Does this appear to be a confirmed tamper?
Your Honor. One is she's testifying off a document that I've objected to that is not in evidence.
Sustained. Go ahead.
Well, at this time, Your Honor, state would tender state's exhibit number 1, 3, and 4 under the business records, exception as her being a custodian of record.
Again, I object to states 1, 2, 3, and 4. It is based on
Hold on.
hearsay.
What are the exhibits?
States 1, 3, and 4.
1, 3, and 4.
Object as to the content inside. It is scientific. She does not have the knowledge in reference to how the results are made, and she's just reading off a report.
Okay. Yeah. Anything else?
No, Your Honor.
Overruled. They are admitted. You want to question and attack the science behind it. You're entitled to look into that during cross-examination. But as a custodial witness, this court finds that she has the ability, training from and experience to testify to business records introduction in this matter, and it's admitted. 1, 3, and 4 states exhibits. Go ahead.
Thank you, Your Honor. Back to my original question. On page 4 of state exhibit number 1, does this appear to be a confirmed tamper violation?
Yes.
What does it mean to be a confirmed tamper violation?
That means that, at some point in time, the info monitor, was tampered with, meaning, like I said, it was either something blocking it or, removed that caused the, alert. However, for this particular case, it was tampered with, meaning something was blocking the info monitor.
How are we able to know that?
They'll say confirmed tamper, meaning something was blocking it, or confirmed removal. For this particular case, it's a confirmed tamper.
Okay. And it says that it's a confirmed tamper with alcohol, is that correct?
With traces of alcohol, yes.
So what does that mean?
That, although it was tampered with, it did pick up some alcohol traces, but the alcohol was not confirmed due to the tamper.
But there was some traces of alcohol detected with the device.
Yes.
Can we see the amount of alcohol that was, that the device detected, even though there was tamper via the TAC value?
We can see it on the graph.
Yes.
It's on the graph, but they're not gonna give you an actual percentage because it was tampered with.
Here.
But that was the device's reach.
Yes,
And that date was October 29th of 2024.
yes, says that.
And then on page 5, this graph, does it show us the amount of times that the device was confirmed to be tampered with via its readings?
Yes.
And then we have a violation on Tuesday, January 28th of 2025, is that correct?
Yes.
Now, what was the violation on this date?
It was, another, tamper.
And was it again a tamper with alcohol detection?
Yes.
What is the bond condition of that tampering falls under? Is it a crime to commit tampering of a Scram device?
It's part of his bond conditions, and I'm going to go through his contract where it says that tampering is a violation of the Scram device.
Okay, on the bond, you have a bond conditions, thank you.
I don't have the bond conditions. I have his contract with RMS monitoring for his Scram device where he signs his initials that he knows that tampering is a violation of the Scram device.
It's a violation of law?
The Scram device, that it counts as a violation of tampering.
Okay.
And then it appears that we also had a violation on Tuesday, January 21st of 2025, is that correct?
Yes.
And was that, what kind of tamper was that again?
It's a confirmed tamper with alcohol detected.
So again, the device was detecting alcohol, but the device was tampered with, so we're not sure about how much.
Right.
And then we had a violation on Thursday, January 23rd of 2025, is that correct?
Yes.
And what was that? What was that violation?
Confirmed tamper with alcohol detected.
And then it looks like we also had one on Monday, January 20th at 2025, that's correct?
Yes.
Now, what was this one?
Just a confirmed tamper.
So the device didn't detect any alcohol, but we can confirm that the device was tampered.
Correct.
And if we look at the descriptions of the tamper on this date, how many hours does it look like the defendant was tampering with the device?
Over 24 hours, about 2 days.
Is that in a report or something that you have? Does it print out a report that memorializes those suspected tamperings?
Yes, it'll have the timestamp.
May I see? Thanks. Okay. Go ahead.
And again, the device tests over every 30 minutes, is that correct?
Every 30 minutes, yes.
And then we had a confirmed violation on January 16th of 2025, is that correct?
Yes.
And what was this violation?
They confirmed tamper with alcohol detected.
And that tamper began on Thursday, January 26th, and the device did not again return to baseline until Friday, January 17th, is that correct?
Yes.
And then there was another confirmed tamper beginning on January 17th, is that correct?
Yes.
What was that confirmed tamper?
Confirmed tamper with alcohol detected.
Now, that one didn't return to baseline again until January 18th of 2025, is that correct?
Yes.
So what was the confirmed time of that tamper?
About 18 hours.
Let me ask you something too on these reports. What the court has noticed is the reports reflect potential tampers and then also confirmed tampers. So how does that work? Because a potential isn't the word confirmed, it's potential.
Right.
So is it a red flag that alerts the Scram officials to do further analysis to determine a confirmation or not?
Every alert, the AMS analysts have to look at, and they will determine whether it's an actual violation or not. So each and every alert that's generated by the Scram device, they have to look at it and determine whether.
Those initial alerts, are they referred to as potential tamper?
Yes.
Okay, so it's a potential tamper that has to be analyzed
Correct.
fully before it's confirmed.
Correct.
Okay, I never understood that sequence because I'm looking at potential and that's not good enough for me. You know, I want to know how the step went to confirmation.
Right. Like I said, they take a look at each and every one of those alerts, and they have to do their own analysis to determine whether it's an actual confirmation. And if it is confirmed, they'll send a non-compliant report showing that it's a confirmed violation.
I'm trying to use state's exhibit number 3. Does this show all of the potential tampers or the potential positives that the defendant had in the history of having his Scram device?
Yes.
Does it also show how many times he changed out his Scram device?
Yes.
So was he given his first Scram bracelet on April 11th of 2023?
Yes.
When was he given his second Scram bracelet?
February the 6th, 2024.
And then when was his last Scram?
October 29th, 2024.
And through this report, it's 24 pages. Are there several positives that show up in this report?
Yes.
But they're not all confirmed positives, is that correct?
Yes.
So for example, on January 17th of 2024, it looks like he had 16 positives on that date that the device detected.
Yes,
But that is not any of the confirmed reports that we have.
it's not.
So these were not able to be confirmed as actual positives.
That's correct.
But those dates that we have confirmed tampers from January, it does show tamperings and positive results on those days, is that correct?
Yes.
And since April 10th of 2025, have there been any positives or tampers or equipment alerts on this device?
It's April the 10th?
Yes.
No.
So from April the 10th to June 3rd, there haven't been any positives or tampers even suspected.
Correct.
I'll show you what has been marked as case exhibit number 4. Is this the client contract?
Yes.
What does the client contract include?
It has all of the client's information, court PO information. It'll go over the billing, with the monthly billing, the fees, and also the do's and don'ts of the county audits.
And does it include a participant agreement?
Yes.
Does it include all of the things that the defendant is banned from using while wearing this device?
Yes.
What is he banned from using?
He's banned from alcohol consumption, any and all products that contain alcohol, like mouthwash, medicinal alcohol, shampoo, things like that.
So he's not supposed to use any products other than soap and water.
Correct.
And he had to initial there, is that correct?
Yes.
Under tampering, does it say that any use of these banned products or any topical application of a product near the monitoring device in an attempt to tamper with or alter its readings will be considered a violation of this agreement?
Yes.
And did he initial there?
Yes.
Did he also initial that he's not supposed to remove, tamper with, or place any obstructing material between the monitoring device and his leg?
Yes.
I have no further questions, Jerome.
Good morning again. I'm gonna give you these that you testified to, okay, ma'am?
When you're referring to these big exhibits, is that 1, 3, and 4?
Yeah, that have been marked. That states 1, 2, 3, and 4.
I've got states exhibits 1, 3, and 4 admitted, but is there 2 in there?
1, 3, and 4.
1, 3, and 4.
All right, go ahead.
Did you supervise Mr. Raleigh?
I saw him a few times when I came to Beaumont, I think once or twice.
The date that he first got his Scram bracelet, what date was that?
That was April the 11th, 2023.
And were you the one that, put it on him?
No,
And how often was he supposed to report to your company, for testing?
I believe initially every 2 weeks, that's when we come to Beaumont. He's more than welcome to drive to Houston as often as he needs to. But we do come to Beaumont every 2 weeks.
Okay.
I believe that he was given permission to report once a month, if I'm not mistaken.
So how long did he come to your facility every 2 weeks?
I'm not sure because I'm not the person that comes to Beaumont, often.
You were asked to bring the records of Mr. Raleigh. Did you bring those records of how long or how many times he went to your facility to have the Scram checked?
I don't know. We have a report that shows how many times he downloaded. But it's not gonna show, what we have here does not show the days that he reported.
Okay, so did he report at least once a month?
I'm not sure because I'm not the person that saw him, so I'm not sure if he was reporting once a month.
Do you know how many times he totally reported to your agency before this date and the date he started?
No.
Well, you had to report sometime because you changed the bracelet out.
Yes.
Why did you change the bracelet out?
I'm not sure.
Okay. Was there a reason? Do they go bad?
So we have a yearly, annual maintenance, what we call annual maintenance, where they have to come in and swap out the device.
Let's stop right there. Tell me why you have to have annual maintenance. Why do you have to have an annual maintenance on the Scram?
Where AMS, has asked us to, allow the client to wear the bracelet for 360 days. Then, remove it, they're sent back to AMS for repurposing.
Okay, so why do they have to do that within 260 days?
Sometimes the clients don't get a brand new bracelet. They may get a bracelet that, has been used prior.
Okay,
So, somebody else may have used it for 100 days before the person got it, installed, so they may only be able to wear it for 260 days.
so how do you know that whether or not, do you have records of whether or not he received a used bracelet or not on any of these occasions?
There is a way to find that out, but I don't believe it's in this reporting.
Okay, and how did AMS decide that within this period of time, they have to bring that unit back to repurpose it? What happens?
We get a notification, stating that it needs to be swapped out.
No. Why did they determine that they had to take that unit off market and repurpose it? What happens to that unit?
It goes back to AMS.
Now, you're missing the point. You don't know why they determined that they have to go back and repurpose it. Like, is there possible problems, or do they have to reboot it, or do they have to clean it out and put new stuff in it to get better readings? Do you actually know why they do that?
I don't know exactly
Okay.
why they do that.
But you have to do that, right?
Yes,
And a lot of times they have used bracelets if it's within that time period.
yes.
And you don't know whether or not Mr. Raleigh received one of those used bracelets.
I do not know that.
Okay. Now, the other question now is that if you had all these violations or potential violations, was Mr. Raleigh ever apprised that, hey, you've got some problems with this bracelet, you're coming up positive? Do you know if he was told?
I have no idea.
Well, you have a lot of violations before April or May or whatever it is that we're here today. Do you know whether or not he was ever advised that this is a problem and you're violating or tampering the Scram?
I personally never spoke with him about that, and I don't know if he spoke to anybody from RMS, in regards to that.
When you say that it detected alcohol, do you know what type of alcohol it detected?
It's, I believe is, I
Well,
can't think of the word.
Let me ask you this, how many types of alcohol are there?
There's breath alcohol
Huh?
and breath alcohol.
No, I'm talking about consumption alcohol, because you're not saying that this unit detects breath. Does
It does
it?
not.
No, it does not. And how does what does this unit detect?
It detects alcohol, that basically comes out through the skin.
Okay, evaporation.
Right.
Okay, so what types of alcohol comes through, or is the ethanol, alcohol? What types actually come through the skin? You don't know, do you? Do you know how many products contain alcohol or ethanol that could be detected in the world today?
A lot of,
A lot. I mean, almost a lot of things have it, right?
right.
Do you know where those samples, what it actually detected?
I do not.
What are some of the things that you know of that possibly, you said mouthwash was one, right? Correct?
Correct.
Toothpaste?
Correct.
So that's hygiene. How about any type of soap?
If it has alcohol in it, yes, it would.
Okay, how about lotions? Okay, mosquito repellent.
I've never looked at the back.
Yeah, right. But it could, right? So how, you don't know how it differentiates between, or does it just, the different alcohols? Or does it just pick up any type of alcohol or detection?
It'll pick up any type of alcohol.
Any type of, at all? You're not saying that he consumed alcohol in these tests?
That's not what the reporting says. The reporting says tampers.
Okay. Now, how did he tamper with it?
We don't know that.
Well, in states, whatever you have there, you testified that, for instance, well, strike that. In a couple of things that you testified to, you said that tampering went on for 24 hours or more. The other one was 18 hours. Remember testifying to that?
Yes.
How does someone tamper that long with your device?
So in order for it to be a tamper, it has to be blocked. So something has to be blocking the skin and, between the skin and the ankle monitor. What device they use or what they use, we're unable to determine that.
On the days you testified, was he ever, do you, in your reports, indicate that Mr. Raleigh was notified of what were you doing over that 24 hours or 18 hours or 30 hours to tamper with this device?
Can you repeat that one time?
Yeah, I mean, did anyone from your company say or notify him, why do we have a tampering for 24 or 30 hours or 18 hours? What were you doing with this device?
Our corporate office, they will contact the client if needed.
Okay,
That's only if it's been requested by AMS.
okay.
They will,
Hold on a minute, because we gotta get, do you have anything in the records that anyone contacted Mr. Raleigh?
not sure.
Do you have anything that says that AMS contacted your company or Mr. Raleigh to determine what was going on?
AMS does not contact the client.
Okay, did AMS contact you through
I'm
your?
not sure.
Okay. Because this is over a period of time where you're saying it's either positive or false or potential. Is that what it is, tampering? Is that what you were saying?
For this particular case, it's, they're all been confirmed.
Well, you just testified that there were possible potential and not confirmed. You remember
Oh,
testifying?
yes.
But But in all these cases, do you have anything in your records that says that AMS contacted you or you contacted the client saying, what's going on? What are you doing with this, Scram unit?
I think I provided the notes, the client's notes, but it's not here. So if I had a copy of that, I could go through the client's notes to see.
I would really like that because I don't think I was provided with that either, ma'am. Where did you provide those notes at?
I think it was sent to, okay, I'm sorry then.
Where are the client's notes?
We have copies of the notes. I can go into his account, print them out and, provide them.
They're readable for, okay.
Yes.
Subject to that, Your Honor, I'd ask for a short recess or something so I can get those notes. I'd like to
What do you mean
know,
short recess?
huh?
What do you mean short recess?
Just to get those notes so I can look at them. I think they're important as to the.
Oh, okay. Yeah. It would you be, so can we help her get to a phone or something to get those?
She need a computer?
Oh, okay. Would you be so kind?
Yeah.
Thank you. We're in short recess.
She may need to get printed out somewhere.
She can send it to me.
What is that?
That means that we haven't received, any data from the bracelet for a period of time. But he's gonna have a lot of those because he was granted permission to report, to download once a month.
Okay.
So after a couple of days, they'll get a critical communication alert, meaning that they need to report to do their downloads.
And then I guess there was another battery change in October of 23.
It looks like he had a battery, replaced battery alert that generated in October. And, I'm not sure when, yeah. Okay, so it looks like he reported, November the 2nd to have the battery replaced.
And that was every 3 months you have to have a battery replaced?
That's correct.
And he did that? Right?
Yes.
And I guess there was no problems up until that time that you were aware of? I didn't see anything that says we were receiving any false positives or positive that you were tampering or anything else with that. We agreed?
Yeah, prior to that, there's no notes.
Okay, now January 1st of 24, client,
24 or 20,
January 24th of 24, which is on page 4. Called client regarding a bracelet replacement. Why would he have to have his bracelet replaced?
that means that it was just, time to replace the bracelet.
Okay, and did he do that?
So he reported, February 6th, 24, and that's when he got another bracelet, yeah.
Another bracelet. And then there, on page 5, there's a number of things, or a number of times that says having problem contacting or making, or something, the bracelet has not made contact with the network. What does that mean?
That he's not downloading, but again, it's because he reports to the Beaumont office to download.
Okay,
So
so
it just means that the bracelet hasn't contacted the network in over a period of time.
okay. And then he had scheduled maintenance again in May of 24, is that correct? That's on page 5.
Yeah, he had a battery replacement on May the 7th.
And then, in August of 24, he downloaded again, I guess, right? page 5 on the bottom. Client will meet Nick. I
Yes.
guess it was August
Yeah,
13th.
that's just a note that they put it in that he was going to meet with the guy. This
Okay.
issue, I don't know, yes.
Now, maintenance was performed on August 13th, correct?
Yeah, another battery replacement.
Okay, and then if you go to page 6, it says on August 13th of 24, confirmed obstruction from August 10th at 8 AM to August 11th at 6:30 PM. What is that?
You're on page 6.
I'm on page 6,
At the
right
top
at the
of the
top.
page?
Yep,
I have start 8/10/24, 5:08.
right. That's what I said.
8/11/24.
To 6:30 PM. Right?
Yes, that's correct.
Okay. Where did that come from?
That comes from, once, AMS will confirm, the data or the alerts, they'll send that or they'll include that into the client's, account. And our, technicians in our corporate office, they'll look at that and put that note in.
Now, question is where did that come from?
What came from what?
Well, where did that is tampering confirmed?
Oh, that comes from AMS.
Oh, yeah, but what, did it come from the old bracelet or did it come from the new one?
So that would come from bracelet, that comes from his second bracelet.
So that's the new one.
Right.
Okay, well, he just put that on that day.
He didn't put it on that day. That the obstruction is from,
Scheduled maintenance was performed, battery and faceplate replaced August 13th, 2024 at 1:30 PM.
yeah, that's just a battery. We don't swap out the bracelet when we do batteries. So that scheduled maintenance is just a battery.
Okay. And then it came back in September. Client came in, downloaded all the meetings, right?
Yes.
And you scheduled a equipment replacement for October 29th of 24. Right?
Yes.
And did he do that?
Yes, he reported on, October the 29th, 24, for our new bracelet.
Yeah. Did he have his bracelet replaced
On what date?
somewhere around October?
Yes, he
Okay.
had it replaced, October the 29th.
On page 6, you got page 6, ma'am?
Yes.
It says potential tamper. January 16th of 25. 1:12 PM.
Correct.
Says fit check is required. What is a fit check?
We need to make sure that it's not too loose or too tight.
Adjust bracelet and ensure proper fit at lowest part of ankle. Correct?
Correct.
And then connect bracelet to complete reinitialization process. What is that?
So it basically means, we have to find a baseline. The IR has to have a baseline. That's what it is.
So they didn't have a baseline before January 16th of
It
25.
does, but every time you remove it to do a fit check, you have to, do a new baseline.
Okay, so you had to remove it at that day?
Yes. Mhm.
Okay,
You have to, pretty much undo the straps tighten it, make sure that it's a good fit.
And when you did that in January of 25, okay, you said you informed him that his bracelet was in need of maintenance, and when could he come back to the office? Right?
What date are you looking at?
January 16th of 2025. Under potential tampering, you knew that there was a potential tampering, and I think you testified to it. And you told him that the bracelet needed maintenance.
Yes, called and informed him that his bracelet was in need of maintenance, asked
When
when he would be able to go back into the office. Client says that he is in the middle of nowhere at the moment and doesn't drive. He would have to get a ride and isn't scheduled until his next town.
Okay. And then what happened, you go to the next page in February 6th, what happened after that? There's another potential tampering. Fit check is required. It's on page 7.
Fit check is required. First, use maintenance link on client's equipment tab. Second, adjust bracelet and ensure proper fit at lowest part of the ankle.
Right.
Finally, direct connect bracelet, last complete reinstallation process, transfer alert to AMS.
Battery needs to be replaced.
Battery needs to be replaced, battery faceplate.
Okay. Provide kit wipe or fine brush or spray with yellow Windex. What is that all about?
It's just part of the process when doing batteries. And anytime that we take a battery out and put a new one in, we make sure that the area is cleaned before putting the new battery in.
And you told him that his next maintenance date was February 11th of 25, correct? And he showed up
He showed up on
February 11th of
February the 11th.
25. So you told him when it was and he showed up.
Yes.
Okay. Now, on February 11th again, you didn't replace the bracelet, right?
No.
Okay. It showed obstruction. It showed tampering. All these things. And I'm on page 8, right?
Yes.
So what happened?
This is just to note that the potential tampers were analyzed by AMS and confirmed. And once they're confirmed, they were provided to us. Then we provided that to the agency. So this is just a note of that, stating that they were confirmed tampers.
And this is all the time in which you're replacing batteries and wiping it down and cleaning it and doing whatever it is, right?
I'm sorry, say that one more time.
This is during the period of time that we just talked about, that you were wiping it down with Windex and redoing the batteries and doing whatever the maintenance was, right?
Yes.
Okay. Alcohol detected. Let's go to the bottom of February 12th of 2024. Not confirmed as consumption. Environmental alcohol contaminant present. See that?
Yes.
What is that?
It's just a note indicating that alcohol was detected, but not confirmed.
So there again, when you did see, it doesn't tell you what type of alcohol, whether it's consumption or not, but somewhere he has come into contact, or his skin or the evaporation has come into contact with alcohol.
Correct.
But you don't know what the source is.
No.
Called client about the violations. He agreed to be more careful, stated he retired, doesn't know what could cause it. Is that right? And that's February, right? Of February 12th? At the very bottom.
25.
Yeah. He agreed to.
Of 25. Page 8.
Yeah, called client about violations. He agreed to be more careful and stated he retired and doesn't know what could cause.
Let's go to, page 9. You have alcohol detected, confirmed, detected. Again, not confirmed as consumption, environmental alcohol contaminant present.
Correct.
Called the client, reminded them to refrain from using alcohol containing products, right?
Right.
They think it might have been a spray they had started using or will refrain from using it going forward. What type of spray did he say?
Doesn't say.
Okay. And when it says critical communication, that is,
We have.
you're just waiting for him to come and download it. So that's because he's on a monthly reporting and they want it like every 2 weeks.
Yes.
The last date I have of his notes is June 18th of this year, 25. Correct?
Correct. He's due for a battery.
It appears that Mr. Raleigh has been compliant with all your company's requests except for the alerts that you've received. He's come in, what I mean by that is he's come in on time, correct? On the date he's scheduled.
Yes, I think so.
He's abided by whatever the replacements or whatever, when you communicate with him, you've gotten a hold of him, right?
Yes.
And told him what he needed to do and he's been obedient with that.
Yes.
Correct. Okay. Do you realize that he doesn't live in Beaumont? He lives up in East Texas, kind of away from here. I know you're from Houston, but from not around here.
I think he mentioned that to me one time.
I think it was Evendale or somewhere around there that he lives. You don't know where. I bet you've never been to Evendale. Okay. But he's been compliant and any concerns, he's tried to address them with you, correct?
Yes.
Subject to recall, Your Honor, I pass the witness.
Anything else, State?
Yes, Your Honor.
Go ahead.
If you look at Defense Exhibit 1 at page 6, there was a confirmed tamper on August 13th of 2024. Is that correct?
Which one are we looking at?
Defense Exhibit 1, the one that you were just looking at.
Okay.
Page 6.
Okay. Okay.
And that date, August 13th, or I'm sorry, I guess the violation started August 10th and ended August 11th. He had a confirmed obstruction with alcohol detected, is that correct?
Yes.
Now that was confirmed after he had come in from his scheduled maintenance, is that right?
Yes.
So the obstruction would have been several days before his scheduled maintenance, if it started on August 10th and ended August 11th.
Yes.
It was confirmed in what method?
Like I said, AMS, they confirmed, the data and sent it to us. I guess I'm not understanding the question.
How is it, yeah, what is used to confirm? Is another test given or is?
They look at the temperature, they look at the IR, which is the baseline that the bracelet has initially when they come in and get it put on. So anything outside of the baseline readings and the temperature, will determine whether it's confirmed or not.
They're reviewing the original alert. Is that what you're saying? They're not doing a separate test.
Oh, no, they're
Confirm.
reviewing the original.
You know, like taking another specimen or sample of the man. They are taking the data from the original alert and then retesting it to determine accuracy.
That's correct.
Okay.
And they sent you a report for that date confirming the tamper, right? Is that
Yes.
correct? And then on January 16th, the defendant was called and informed that he needed to come in for maintenance because there was a potential tamper and he needed a fit check.
Correct.
What was the date that he actually came in for that fit check?
He came in on February the 11th.
So almost a month after being told that there was an issue, he finally came in and got that fit check for his regular scheduled maintenance.
Yes.
So he didn't comply with what your office had requested of him.
It took him about a month, but eventually he complied.
And when you did do the download, finally in February, you received several confirmed tampers. Is that correct?
Yes.
And just so we're clear on the record, the dates of those confirmed tampers were January 16th, January 17th, January 19th, January 21st, January 23rd, and January 28th of 2025. Is that correct?
Yes.
And then on March 25th of 2025, did you receive information that there was a confirmed obstruction on February 27th of 2025?
Yes.
And was there also alcohol detected during that time?
Yes.
And that was after he had come in for his fit check and his scheduled maintenance.
Yes.
Now, based off of the reporting from March 26th and March 27th, there is the ability to tell when there's environmental alcohol and it's not alcohol consumption by the defendant. Is that correct?
Yes.
So they were able to confirm that on those dates, it wasn't alcohol consumption and the device hadn't been tampered with. And he was called and told not to use any banned products or anything with alcohol in it, correct?
Correct.
So those dates are not part of the confirmed tampers that we have in front of us, is it?
No, because they're not confirmed consumptions.
I have no further questions, Your Honor.
Can you listen to the court, what the state contends are the confirmed tampering dates?
August 10th of 2024,
Stand by. Okay,
January 16th of 2025, January 17th of 2025, January 19th of 2025, January 21st of 2025, January 23rd of 2025, January 28th of 2025, and February 27th of 2025.
eight separate events. Am I adding that up right?
Yes, and there were 2 events on January 23rd of 2025, so it'd be 9.
Say it again.
There were 2 events on January 23rd of 2025, so it'd be 9 events. But 8
I'm a little
dates.
fussy about the 2 events. What are the 2 events again?
2 different tampers, same day.
2 different confirmed tamperings, but on the same.
Now, are all of these? Okay, what's the difference here on the dates for tampering and positive readings?
So all of them but one are confirmed tamperings with alcohol detected. Now, we don't know how much alcohol there actually was because of the tampering, but they're tamperings with alcohol detected. One of them is just a tampering, so no alcohol was detected, but it was a confirmed tampering with the device.
Out of the 8 dates here. Is that right?
Yes.
Defense.
2 questions, ma'am. Maybe more. You don't know what type of alcohol was in the system, correct? Where it
Correct.
came from? And you acknowledge that besides an alcoholic beverage, other products do have alcohol.
Correct.
That could be detected by your unit.
Yes.
And you can't determine that, or you don't have the qualifications to determine that today, is that correct? Whether there's a difference. You're not a researcher, all you have is a report, correct?
Right, we won't know which type of alcohol it is, correct?
That's right. And number 2 is there was an inference that when you notified him in February of 25, it took him over a month or a couple of weeks to get to your facility. Is there anything that he was trying to avoid you? That's the implication that the state was trying to get to. Did he ever refuse to come in from your notes?
No.
Did he have regular monthly or bi-weekly appointments at your company?
Yes.
Is there any indication that he ever missed any of those appointments?
I wouldn't be able to tell you that based on what I have.
Well, the notes are there.
Right.
Right, is there anything in your notes that says that?
No, that he never showed up.
Yeah, he never
No,
showed up.
it's not in the.
Every time he was scheduled to be there, he was there, correct?
It wasn't immediately, but he eventually reported.
Then can you show me in the notes where you requested him immediately to show up at that office?
On several of the notes.
Or official proceeding is pending or in progress, and it's pretty clear he knows he's under indictment and he's got bond conditions. That fits that condition. He alters, destroys, or conceals any record, document, or thing with intent to impair its verity, legibility, or availability as evidence in the investigation or the official proceeding. And I think you can read this clearly to apply to taking of specimens. If you attempt to tamper with the device that is ordered as a condition of bond to have either urine or a specimen of some sort of the person, whether it's urine or breath in this case, and in some way it impairs its ability to be provable and accurate as evidence in an investigation or official proceeding. And that's what we're talking about here, an official proceeding or of a bond matter, then that is a crime, which is a violation of condition 1 of a bond condition, or makes, presents, or uses any record, document, or thing with knowledge of its falsity and with intent to affect the course or outcome of the investigation or official proceeding.
On January 16th, that they wanted you to come in so that they could check your device. Is that correct? January 16th of 2025. And you did not come back until February 11th of 2025.
I came in every month they appoint.
But when they told you that they wanted to check out your device, you did not come in until 3 weeks later. Is that correct?
I asked them if it was okay.
Is it yes or no? Yes or no, and you can explain. Yes or no, sir, and then you can explain your answer.
So they didn't call you on January 16th to come in for a fit check.
Yes, they did.
And you showed up on February 11th, is that correct?
Yes, ma'am.
Because you told them you're in the middle of nowhere at the moment and you don't drive and you have to get a ride and isn't scheduled until your next download. Not that they told you it was okay, but that you just weren't. Is that correct?
As I recall the phone conversation.
June. Now we're in the 5th month of this, but he's had a steady green light, as it were, on his proceedings. Wow. I'm gonna hold open the motion. I'm not gonna revoke his bond under these circumstances. But the next positive thing, anything we get a positive confirmed, let me know and we'll rush in here, try to get to the bottom of it. Can everybody be ready for trial here in a month?
I'm ready to go.
Thanks. We're gonna try to get that one, unless there's some this one forward. All right, anything else?
Not from the defense.
All right. We're in recess. Thank you.
No, I'm totally fine. Like, love it, love it, love it. Can I ask why?